colleagues, and welcome to this morning HDIM session number 12. My name is Katarzyna Gardabhadze, and I am the first Deputy Director of ODIHR, and I will have a pleasure to moderate this morning's session that will be dedicated to three subtopics of the rule of law: the prevention of torture, possibility to exchange views on the question of abolition of capital punishment, and the protection of human rights when fighting terrorism. Before we give the floor to our distinguished introducers, let me just say a couple of words of technical nature and organizational nature. The speakers list has now reached 50 speakers, so it is closed. However, participants can still register on a reserve list. Please remember that you can only take the floor in the capacity in which you are registered, and only entities registered on the speakers list can be represented. Please also keep in mind that because the plenary hall is rather narrow, we have introduced designated entrances, and to avoid traffic jams in the plenary hall, please kindly use them, and also keep in mind the seating arrangement that is designated in the plenary hall. Please also kindly familiarize yourself with rules for filming in the plenary hall, as indicated in the General Information and Organizational Modalities document available on HDIM webpage. We would kindly ask all participants to make their interventions in meaningful, orderly, and respectful manner and language, and if possible to submit statements before the session to the interpreters and to distribution of documents to ensure that the flow of documents reflect the discussion. The statements should be provided to the documentation desk in front of the plenary hall. The last news that I would like to make before giving the floor to our introducers is an invitation on behalf of our director to today's reception, which will take place at 8 o'clock in the evening at Villa Foxal. Participants can collect their invitations in the delegation's pigeonhole or on the ODIHR publications table. The buses will leave from the venue at 19:45, and for public transportation options, please refer to the notice wall in the foyer. With this, I will now introduce our distinguished speakers. The first one is Dr. Mykola Gnatowski, who holds an LLM and PhD in international law from Taras Shevchenko National University in Kiev. Since 2002, he has been teaching public international law at the Institute of International Relations of the same university, specializing in international humanitarian and human rights law, as well as international criminal law. He is a member of editorial boards of international legal journals published in Ukraine, Belarus, Moldova, Romania, the Russian Federation, and the United Kingdom. Since 2009, he has been a member of the European Committee for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment, known as the CPT, and its second vice president in 2013-2015. He was elected as president of the CPT in March 2015 and re-elected in March 2017. As an independent consultant, Dr. Gnatowski has been involved in many projects implemented by the United Nations, the OSCE, Council of Europe, International Committee of the Red Cross, as well as a number of non-governmental organizations in various European and Asian countries. He also cooperates with Democracy Reporting International as a senior legal advisor for its projects in Ukraine. Dr. Gnatowski, please.
Thank you very much, Chair. Good morning, ladies and gentlemen. It is a great honor to address you this morning and to introduce the panel which deals in particular with the prevention of torture and other forms of ill treatment in the OSCE region. I have the honor to represent here the European Committee for the Prevention of Torture, which is a treaty-based human rights monitoring body. Its task is to examine the situation of people deprived of their liberty by a public authority in various places of detention, such as police stations, prisons, holding facilities for migrants, psychiatric hospitals, social care homes, military detention facilities, and so on. Our committee does so by means of periodic visits to the states which are parties to our convention, and also the so-called ad hoc visits when such visits are required in the circumstances. For example, the CPT carried out ad hoc visits recently to the hotspots for holding migrants in Greece and in Italy, to Belgium during strikes by prison staff, and to Turkey following the failed coup. Under the European Convention for the Prevention of Torture, adopted in 1987, the CPT visits states which are parties to this convention. Currently, those are 47 member states of the Council of Europe. In addition, it has special agreements and carries out visits for example, to Kosovo on the basis of an agreement with the United Nations Interim Administration Mission in Kosovo. Our convention is open for accession by non-Council of Europe member states upon an invitation from the Committee of Ministers of the Council of Europe, and this of course includes the participating states of the OSCE, which are not members of the Council of Europe. Every year we carry out some 18 visits, totaling to some 170 days, which means that every second day of the year, the CPT's delegation is in the field carrying out a visit to places of deprivation of liberty. Our convention is based on two principles: cooperation and confidentiality. Cooperation means that our committee cooperates with the states because it is an intergovernmental initiative and it is designed not to create difficulties to states, especially in our interesting times, but also and primarily to help the states to ensure that they comply with their own constitutions, with their international obligations, including also the obligations within the framework of the OSCE. We have unlimited access to the territory of states and the right to travel without restriction, unlimited access to any place where persons may be deprived of their liberty, and the prerogative of interviewing detained persons in private without witnesses. The principle of cooperation also includes the government action to implement our recommendations. The second principle is confidentiality, which means that visit reports and responses are made public only at the request of the party concerned. There is an exceptional procedure envisaged in Article 10, Paragraph 2 of our Convention, whereby in case of persistent non-cooperation from a state, the CPT can make a public statement describing the situation. In our 28 years of existence, we have resorted to a public statement only 8 times, which shows how exceptional the measure is. 90% of our almost 400 reports have been published, and on top of this, there are states who not only regularly publish our reports and their responses, which are basically in 90% of cases, but also there are states who have adopted the so-called automatic publication procedure, whereby our reports, with their prior permission, general permission, automatically are published, and so are their responses. These 8 states are Austria, Bulgaria, Finland, Luxembourg, Moldova, Monaco, Sweden, and Ukraine in the alphabetical order. The publication of our reports is very important. It's not only indicative of a healthy and constructive dialogue with the committee, but also provides an opportunity to open a wider debate on the issues raised in them, and to highlight progress made by the authorities in the implementation of our recommendations. This is also a source for anyone who is interested in the matter of improving the conditions in places of deprivation of liberty. In the annotated agenda for this session, we have certain questions asking in particular why torture and other forms of ill treatment is still an important subject in the OSCE region. And the reasons are multiple. There is one general reason, which is boiled down to the fact that human dignity is still not the utmost priority, unfortunately, in practice in some areas. But of course, there are particular reasons in the, let's say, when it comes to police investigations, and their torture and ill treatment happens when police are not equipped and not trained properly to investigate crime. In prisons, often the material conditions are bad, the situation of staff is bad. In psychiatric establishments, in places for migrants, also due to the financial reasons, and also to the fact that such places are rarely a priority for their governments. There are some serious challenges nowadays, and this is something that I wanted to concentrate on now. And this is, of course, combating terrorism, which will be dealt with during this session. But this combating terrorism does not allow torture. The prohibition of torture is absolute, and torture is ineffective and plays into the hands of persons who might be inclined to carry out terrorist attacks. Prison overcrowding is a problem that affects many countries, or most countries, visited by our committee. And we have elaborated very detailed recommendations on how to handle this very difficult problem, together with other bodies, of course, with the Council of Europe. Recently, we've paid increased attention to the detention of irregular migrants. And we have recently published a fact sheet on the standards of treating irregular migrants. And I'm very much inviting you to consult it on the website of the CPT. There is a big challenge to the CPT, which is the frozen conflicts in the European region, which have led to the emergence of self-proclaimed independent republics and other territories which have no or very little international recognition. This poses problems because it means that in Europe we are now dealing with certain areas which are not covered by human rights monitoring mechanisms, including the CPT. We are pursuing our efforts to visit every such region. We have visited the Transnistrian region of the Republic of Moldova 4 times till 2010, when the attitude of the de facto authorities changed and we couldn't any longer speak to detainees in private. We visited Abkhazia in Georgia in 2009, but we couldn't return to the region ever since. We have made serious attempts to visit other places such as Northern Cyprus and South Ossetia, and currently the situation in of the Crimean Peninsula in Ukraine, the Autonomous Republic of Crimea and the city of Sevastopol is very challenging. We last visited Crimea in October 2013 during a periodic visit to Ukraine, made a number of recommendations which we are unable to follow up on currently, and we are strongly committed to doing so. In this case, and indeed for all the frozen conflict zones in Europe, we believe that with good faith cooperation from all the parties concerned, pragmatic solutions should and can be found to make this happen in the overriding interest of human rights protection and in particular the prevention of torture. And finally, a very brief comment on the role of the CPT in the global torture prevention architecture. Within the OSCE region, there is a very wide ratification of the optional protocol to the United Nations Convention against Torture and the establishment of the national preventive mechanisms. We welcome that very much, and we are committed to our relations, the certain type of triangular relations between the United Nations Subcommittee for the Prevention of Torture, the national preventive mechanisms, and the CPT in the European region. And I believe that this cooperation should be based on principles of complementarity and subsidiarity, as enshrined actually in the text of the optional protocol to the United Nations Convention against Torture. I believe that this synergy between the national preventive mechanism, the regional mechanisms such as the CPT and the UN mechanism should be extremely useful to boost the effectiveness of our collective efforts in the prevention of torture and other forms of ill treatment. Thank you very much for your attention, and I will be happy in due course to answer your questions. Thank you.
Thank you very much, Dr. Hnatowski. It seems to me that indeed joining the committee is a unique opportunity for OSCE participating states. And maybe I will just say that the principle of cooperation in the prevention of torture is of paramount importance and one that we at ODIHR closely adhere to in this portfolio. And we welcome this cooperation and have enjoyed it tremendously in specifically two areas of focus, which is the prevention of torture in places of deprivation of liberty and strengthening national preventive mechanisms. I will now give the floor to our second distinguished introducer, Mr. Nadir Horry, who is a Human Rights Watch Director of Terrorism and Counterterrorism Program. Prior to joining Human Rights Watch, he served as Deputy Counsel for the Volcker Commission, where he spent more than a year conducting fact-finding missions in the Middle East as part of the United Nations Corruption Inquiry into the Oil for Food program. An attorney by training, Nadim is fluent in Arabic and French. Mr. Horry, the floor is yours.
Good morning. Thank you very much. How do you defeat terrorism? Salman Rushdie was once asked. His answer was simple: don't be terrorized. Now, why start a presentation about protection of human rights with a literary citation? Because the issue of how to protect human rights while fighting terrorism today is not simply about a few measures that need to be discussed or tweaked, but rather it is the whole approach, the structure of how states are pursuing counterterrorism that needs to be discussed. Traditionally, liberal democratic states largely relied on their criminal justice system to deal with terrorist threats. Of course, you had exceptions and abuses, but generally the accepted framework was a criminal law enforcement one. Planners and perpetrators of terrorist acts were treated as criminals, maybe heinous criminals, but criminals nonetheless, and were dealt with through the judicial system. Now, a criminal justice response that is based on the principles of rule of law and human rights is arguably the most accountable and legitimate response to terrorism. It helps avoid an escalation of violence and ensures that any state-sanctioned response is very much placed at the heart of the rule of law framework. And frankly, it worked well overall with many terrorist groups, be it of the anarchist, fascist, extreme left, nationalist, or religious kind of the last century. Now, this model has been under attack. First, after 9/11, and in the last few years in response to ISIS. After the terrible attacks of 9/11, the US decided to move away from a criminal justice response and its underpinning assumptions. It threw out the rule book and decided to wage what George W. Bush called at the time the global war on terror. Now, Bush did not just put aside international law, but also domestic checks and balances by trying to circumvent US courts. This shift in approach had disastrous effects and led to abuses in Guantanamo, Abu Ghraib, illegal rendition flights, torture memos, military commissions, and special registration procedures in the US for foreigners from certain countries. While some OSCE countries joined this disastrous global war on terror, many others provided a useful counterbalance by refusing to embrace the paradigm and insisting on due process and law enforcement tools. But now the emergence of ISIS over the last few years, the increase in terrorist attacks on European soil, and successive populist attacks on judicial institutions and liberal politics have caused cracks in this model. And an increasing number of states, including many OSCE members, are embracing a response that I would argue undermines the rule of law and human rights. So what are some of the new and troubling trends in counterterrorism efforts? I want to focus on 5 key aspects that, taken together, show a drift away from this law enforcement approach and a weakening of the rule of law. They're not exhaustive, but I believe these are some of the key general trends. First, the banalization of states of emergency. Over the last 2 years, countries as diverse as France, Egypt, Ethiopia, Tunisia, and Turkey have cited terrorism as a reason to enact or extend states of emergency. Some of these emergency measures vastly increase government powers to search, detain, and monitor individuals, to shut establishments such as meeting houses and places of worship, and to ban public gatherings or free speech. Other countries like Hungary have adopted constitutional amendments or new legislation to make it easier to declare a state of emergency. And even others have introduced now exceptional powers, usually found in emergency laws, into permanent law, such as the 2016 counterterrorism law here in Poland, or the draft counterterrorism law currently being discussed and probably will be adopted by the end of this month in the French Parliament. Declaring a state of emergency has its place, of course, and international law allows it. But the issue is that these measures are supposed to be exceptional. And today, what we are increasingly hearing is governments saying that a state of emergency is needed as long as there is a high security risk. Now, given that no one knows when the risk will be deemed acceptable in this current day and age, and most politicians, and I can understand why, prefer to err on the side of caution, and to this day I have yet to hear a politician tell its audience, oh, the risk has gone down, it's all safe. The exceptional becomes the new normal. By suggesting that regular laws, procedures, and oversight mechanisms are not sufficient to counter threats and to keep our societies safe, it weakens the premise of the rule of law and relegates it to what I would consider a luxury for quote-unquote normal times, which we don't know when we will return to. And that is a danger for the rule of law when it becomes something exceptional. Secondly, the overly broad and vague definitions of terrorism. Now, the debate about what constitutes terrorism is very, very old, and I have no desire to revisit it today. But the key issue here is that increasingly, countries from Australia, Brazil, Canada, China, Egypt, Israel, Saudi Arabia, Tunisia have been enacting counterterrorism laws or have enacted counterterrorism laws in the last few years, criminalizing non-violent activities that fall far short of what usually is considered material support or participation in terrorist groups. We have documented the use of counterterrorism laws to prosecute and prolong incarceration of political activists, human rights defenders, students, journalists, and trade unionists. Many countries have used broad definitions of terrorism to silence dissenting voices or pressure them. Just in the last few weeks, Turkey has detained and investigated a French journalist, Louis Bureau, for terrorism because he had photos of himself standing with Kurdish fighters in Syria. And this is also happening in countries with traditionally strong rule of law measures. And a clear example was when the UK stopped David Miranda at Heathrow Airport and questioned him under Schedule 7 of its Terrorism Act, not because of terrorism, but because he possessed documents provided by Snowden. The principle of legality under international law requires that criminal laws are sufficiently precise that it is clear what constitutes a criminal offense. The third trend is the criminalization of various forms of expression that fall short of incitement to violence. We've seen a trend of countries criminalizing any expression that is deemed to praise, glorify, apologize for acts defined as terrorism. But what constitutes glorifying terrorism or apology of terrorism? That's a real question, and we have seen courts struggle with it and often silence legitimate forms of expression. And this has affected many people, from activists to children and teenagers saying things on Facebook or in their school courtyard. Now, some of these things are nasty, and I would not want to hear it from my children, but should it be basis for people, for young people to go to jail? In Spain, for example, glorification of terrorism has caught up with artists. And in February 2016, two puppeteers were charged with glorifying terrorism for staging a show that included violent scenes and a puppet holding a sign that referenced Al-Qaeda and ETA, the Basque group. A judge eventually dismissed the charges 4 months later, but meanwhile the puppeteers had been jailed for 4 days and barred from leaving the country. In France, in the wake of the Charlie Hebdo attacks, France has been applying its glorification of terrorism penal code provision very broadly, convicting hundreds of people, including dozens of children, some as young as 13 for referencing ISIS in social media or during altercations with the police. When it comes to criminalizing expression, international law requires strict conditions to ensure that such sanctions do not restrict freedom of expression. The fourth trend is the use of administrative control measures to restrict people's freedom of movement. Increasingly, states are resorting to administrative control measures to control movement. These measures include house arrest or assigned residency, confiscation of travel documents, and regular reporting procedures to police and other places. Now, what is the human rights issue with these measures? People are punished before any crime has been committed, and secondly, there are usually no safeguards or recourse for those affected to properly challenge these measures. Now, let me just be very clear. States don't have to wait for an attack to take measures. And criminal law already penalizes a whole set of preparatory acts and could be used and has been used for the last century to prosecute suspected terrorists or those planning terrorist acts way before they commit an attack. The problem is with this shift to administrative measures is that people are being punished without a real proceeding, without the ability to defend themselves, and usually on the basis of evidence that they don't have full access to. The central figure of the judicial judge deciding who should go to jail is slowly being replaced by an administrative judge, and so far, examining these procedures have shown that these administrative judges, in most cases, are more reluctant to stand up or question executive power. And finally, the last trend, mass surveillance. States have been expanding their mass surveillance practices. Now, there's obviously a legitimate goal to surveil security threats, but any communication surveillance must be necessary and proportionate. Indiscriminate mass surveillance and retention of people's communication for potential future use runs against this. Now, this can quickly get very, very technical, and I'm not going to get into the technicalities, but I want to bring it back to a basic example. How would you feel if the state went into your house while you were away at the office or at this conference just to check that you were not doing anything criminal? They go in, they see what you have in your apartment, they open your mailbox, they look at your mail, they pack everything back in its place, and they leave. Now, I'm sure you would all be very upset, and you would feel that your privacy has been violated. Well, why should we accept it then when it happens online, especially since increasingly a large part of our life is online? Our love letters are online, our private communication, our financial situation. Just because technology allows it does not make it okay to have mass surveillance. Let me just quickly conclude. The issue is not the pursuit of security by states or opposing security and freedoms. The terrorism threat is real, and the state is expected to respond to it. Rather, the issue today is the rush to adopt ever more restrictive measures without a proper assessment of their impact on key freedoms, freedoms that have taken decades to be earned, and rights. And also without a real examination of their effectiveness. An inflation of legislative activity. With every new attack, we're seeing new laws before law enforcement has even had time to absorb the previous law. Incrementally but surely, these measures are weakening judicial oversight, blurring lines between war and law enforcement, and eroding key protections. The impact of these measures is felt most acutely by members of certain ethnic or religious groups, notably Muslims, migrants, and refugees. And this treatment is further eroding their trust in the national authorities. It is essential to stop this drift towards more repressive measures and create the space for a calm, evidence-based discussion on the appropriate response to new security threats. The temptation to adopt new laws and measures after every attack when emotions are at their height should be resisted. States should return to a criminal justice response to terrorism and provide their judicial authorities with the resources to confront these new challenges. This is not naive. The judicial system has shown itself capable in the past of adapting to ever-changing and increasingly international forms of terrorism through better international cooperation and more resources. And many countries have shown that it is possible. But in order to have the space for discussion on how to confront terrorism, it is essential to address the climate of fear, The late US President Franklin D. Roosevelt famously said during his first inaugural address, which coincided with the Great Depression, a much more terrifying time than today, that the only thing we have to fear is fear itself. Thank you very much.
Thank you very much for these really very thoughtful and meaningful words. I cannot agree more that the response to terrorism must be based on human rights and rule of law, and this principle constitutes the foundation and the core of ODIHR's work in the area of anti-terrorism. And I also cannot agree more than rule of law and the protection of human rights and fundamental freedoms should be the norm and not the exception, and should not be sacrificed in the name of national security. So thank you very much again for these words, and also to our first introducer. With this, I will now give the floor to the participants according to the speakers list, on which I have 50 names. So the speaking time will be limited to 2 minutes, and because of this, kindly keep comments brief and to the point, preferably listing the recommendations first. And on first speaking, please kindly introduce yourself with your name and organization or delegation or institution that you represent. With this, I will now give the floor to the delegation of Denmark on behalf of the European Union, followed by the Holy See. Denmark, you have the floor.
Thank you, Madam Moderator. My name is Rika Hughes, and I'm honored to speak on behalf of the European Union, Montenegro, Bosnia and Herzegovina, and San Marino. The rule of law is a prerequisite for freedom, peace, and security. Therefore, one of the EU's key objectives is to strengthen the rule of law at international, regional, and national level. In this effort, eradication of torture and other forms of cruel, inhuman, or degrading treatment or punishment remains of utmost importance. And our international commitments are clear. Torture is explicitly prohibited under all circumstances and without exceptions. We are deeply disappointed by the fact that one participating state recently single-handedly blocked an OSCE text on torture prevention for the 3rd year running. Nevertheless, the EU will continue to work together with our international and regional partners to make torture a thing of the past. The EU therefore supports the Global Convention Against Torture initiative and its efforts to achieve global ratification and implementation of the Convention Against Torture by the year 2024. The EU urges all participating states to contribute to this initiative and to give strong consideration to ratifying all international conventions and protocols on torture and ill treatment, the abolition of death penalty, and the prevention of enforced disappearances. Despite the improvements in recent years, the fight is still far from won. Torture and ill treatment persist in the OSCE region. We are deeply concerned about the several reports of mass arrests, disappearances, torture, and ill treatment of men in Chechnya due to their sexual orientation. We call on Russian authorities to follow international commitments and take effective measures to ensure the safety of all Russian citizens without any discrimination. We also remain seriously concerned about the fate of many people subject to enforced disappearance in early 2000s in Turkmenistan's prisons. And we call on the Turkmenistan government to acknowledge this problem and to take immediate action on outstanding cases. The EU strongly opposes the use of death penalty at all times and in all circumstances. Death penalty is cruel, inhuman, and degrading in nature, even when backed by a due process in a democratic society. The EU calls for universal abolition of the death penalty. As a step towards this, the EU advocates for a global moratorium of the use of death penalty. The EU recommends all states who still practice the death penalty or retain it in law to abolish it. Likewise, the EU strongly calls on all states not to introduce death penalty. In conclusion, the scourge of terrorism affects all parts of the world, and the OSCE region is not an exception. However, the EU firmly believes that the rule of law and respect for human rights must stay at the heart of the fight against terrorism. Acts of terrorism must be investigated, and terrorists must be prosecuted in full respect of the rule of law. The OSCE plays an important role in supporting the rule of law, and we should continue to further the OSCE engagement on this. Madam Moderator, please note that the list of aligned state is not final. The full list will be circulated when circulating our full statement. Thank you.
Thank you very much. On behalf of the EU and all aligned participating states, now I have on my list the Holy See, followed by the Delegation of Switzerland. The Holy See, please.
Thank you, Madam Moderator. I'm Father Miroslav Wakowski. I am speaking on behalf of the Holy See. The Holy See is most pleased that the working session of the 2017 Human Dimension Implementation Meeting is devoted to prevention of torture and the death penalty. However, thorough attention to these two issues alone is not enough. Our delegation calls all 57 participating states to greater action to ensure the timely end to torture and other forms of cruel and degrading treatment or punishment and the death penalty, not only in the OSCE region, but in the world as a whole. Our delegation, rather than making an extensive presentation, takes this opportunity to reiterate a few principled aspects of the position of the Holy See on these two grave violations of human dignity. Rescue to torture is unacceptable and inhuman in each and every case. The Holy See strongly condemns all acts of torture and ill treatment as defined in the United Nations Convention Against Torture and other cruel, inhuman or degrading treatment or punishment, which was acceded to on behalf of the Vatican City States on June 22nd, 2002. The Convention supports victims of torture and respects their rights to complain and to obtain redress and to expect fair and adequate compensation, including the means for as full a rehabilitation as possible. The position of the Holy See on the issue of the death penalty is well known, but I would like to take this opportunity to echo Pope Francis, who stated in his video message to the 6th World Congress Against the Death Penalty that such a penalty is unacceptable, however grave the crime of the convicted person. It is an offense to the inviolability of life and to the dignity of the human person. It should further be noted that no clear positive effect of deterrence results and in the irreversibility of the punishment does not allow for eventual corrections in the case of wrongful convictions. Madam Moderator, the death penalty and the use of torture are not consonant with any just purpose of punishment and are in contradiction with respect for the dignity of every human person. In conclusion, it is the view of our delegation that bloodless means of defending the common good and upholding justice are possible and are a more human form of punishment. Thank you, Madam Moderator.
Thank you very much. May I now ask Switzerland to take the floor, to be followed by the Russian Federation. Switzerland, please.
Thank you, Madam Moderator. I would also like to thank the two introducers for their very insightful presentations. My delegation shares the concern that human rights violations represent a condition conducive to terrorism. The respect of human rights is essential to prevent violent extremism and not an option. In this regard, Switzerland is particularly concerned with the discourse that tries to justify torture and other forms of cruel, inhuman or degrading treatment or punishment with the fight against terrorism. We cannot accept that. The prohibition of torture is absolute. All states have the obligation to make sure that no one, under no circumstance, is subjected to torture or other forms of ill treatment. OSCE participating states have committed themselves to preventing torture and bringing perpetrators to justice in accordance with their international obligations. It seems, however, that the efforts undertaken are not enough. Torture and ill treatment persist, and impunity for such acts is widespread. In 2016, Richard Carver and Lisa Handley published a seminal study entitled "Does Torture Prevention Work?" The two researchers examined the practice of torture prevention in 16 countries from all around the world over a time period of 30 years. The study found that detention safeguards are the most effective instruments to prevent torture. This includes that people must not be detained in secret places, that they can contact their families or friends, and that they have access to a lawyer. The second most important measure to prevent torture is the prosecution of perpetrators. According to the study, if there is impunity for the crime, new cases of torture are more likely to occur. This shows that participating states need to take the fight against impunity seriously, also in view of prevention. And the third most effective preventive measure is the establishment of an independent monitoring system of places of detention. Many participating states have already ratified the optional protocol to the Convention Against Torture and have established a national preventive mechanism. Switzerland welcomes the work of ODIHR in this respect, facilitating exchanges between such mechanisms and improving their effectiveness. We encourage participating states that have not yet ratified the OPCAT to establish a national preventive mechanism and to study the institutional criteria that need to be met in order for such a mechanism to have a real effect on the prevention of torture. My delegation thanks ODIHR for its assistance to participating states in the prevention of torture. In the end, however, it is a question of political will. Switzerland calls on all participating states to reaffirm their commitment to the absolute prohibition of torture and ill treatment in accordance with their international obligations. Thank you.
Thank you very much. I now have the Russian Federation, followed by the delegation of the United States. Russian Federation, you have the floor.
Спасибо.
Thank you. Moderator, dear experts, the Russian Federation is in favor of strict observance of generally accepted international law principles and norms. In our country, we have legislatively guaranteed and effective mechanisms to prevent torture and inhuman and degrading treatment and punishment. An important role is played by the prosecutor responsible for monitoring the work of the forces of law and order that carry out investigations. Now, there is a tendency for an increase in the number of people with respect to whom there is the alternative of house arrest as a very effective measure of interdiction rather than imprisonment. But we are very concerned by systematic violation of human rights in some participating states of the OSCE. As an example, the torture conducted under the secret program of detention of the CIA after 11 September 2001. And in this context, it is worth noting that on a number of occasions at this conference, we have heard promises from the USA to close the prison in Guantanamo, where, according to Amnesty International data for 2016-2017, there are still 59 prisoners, most of them having been subject to no trial or investigation. This has been going on for virtually 8 years. We hope that the current president of the USA will finally close that prison. A second example, Ukraine, where there are still facts of illegal detention of citizens by Ukrainian forces of law and order. These individuals are subject to degrading treatment, to torture, and violation of their procedural laws. And then there is the death penalty. In the U.S., it is still permitted or practiced in 31 states and also at the federal level. Another acute issue is that of combating terrorism, a threat to global security. International terrorist organizations have turned Syria and Iraq into arenas of military action. Their leaders have plans to occupy new territory to create their own state. There is this long-standing problem of the fighters returning to their countries where they take advantage of their experience from the arena of military activity. Now, terrorists use the internet to call for terrorist activity, to recruit new adherents, and to collect financial resources. Now, we have a lot of experience in the prevention and interdiction of terrorist crimes, and we believe that first and foremost there must be good prosecution. That is a good prophylactic measure. We're convinced that we can combat terrorism only through unification of our forces with good mechanisms for prevention and timely interdiction. And we need to cooperate, and we are prepared to cooperate with foreign colleagues. Now, we believe that we need to improve the legal base and have a single approach to determining the essence of terrorist activity, setting up international data banks on terrorist and extremist organizations, and recruiting and training people. We are prepared to share our long-standing experience with foreign colleagues. We hope that international cooperation in the combating of terrorism will be based on the norms of international law without any double standards or dividing terrorists into good terrorists and bad terrorists. The full version of our statement will be distributed through the Secretariat. Thank you for your attention.
May I kindly remind all the speakers that the time limit so that we can accommodate everybody on the speakers list is 2 minutes. I now have the delegation of the United States, followed by the Council of Europe. The US, please.
Torture and cruel, inhuman, and degrading treatment are abhorrent in all places at all times with no exception. Protecting human rights is essential to effectively countering terrorism and violent extremism. Uzbekistan keeps prisoners incarcerated by the previous government on questionable charges, including religious extremism. We are encouraged by the new president's reform efforts and urge more. Tajikistan imprisons members of peaceful political opposition groups in the name of countering violent extremism. Kazakhstan uses charges of extremism to pressure political opposition and to criminalize religious communication. It uses incitement to discord charges to punish expression. In Russia, we are appalled by the banning of the Jehovah's Witnesses as extremist. We raised last week reports of a campaign in Chechnya to torture and kill gay men. Last Friday, Russia stated not a single case has been detected and all accusations are baseless. But Russian human rights ombudswoman Moskalkova told the press she considers the investigation unfinished because she has not received a response on a list of 26 alleged victims. Is the investigation ongoing? If closed, where is the official announcement of conclusions? The UN monitoring mission reports that Russia occupation authorities in Crimea routinely use torture and other abuse, including psychiatric, against Ukrainian detainees. Reports of torture and abuse of prisoners continue in Uzbekistan. We support the OSCE training on prevention of torture and encourage the government to allow international monitors to resume prison visits. We read Turkmenistan's report to the UN Committee Against Torture, but note its unwillingness to consistently allow access to its prisons as it is pledged. It is outrageous that former OSCE ambassador Batir Berdiev has been disappeared for 15 years. How would it possibly hurt the government to at least tell his family if he's dead or alive? The UN Committee Against Torture expressed concern about allegations of torture and mistreatment of prisoners in Azerbaijan. Muslim Unity Movement leaders Bagirov and Husseinov and youth activists Ibramov and Madov alleged they were tortured. In Turkey, we are troubled by reports of hundreds of cases of abuse or tortures in detention centers since the state of emergency. The U.S. position on capital punishment is well known, and we refer you to our written statement. Thank you.
Thank you very much. I now have the Council of Europe, followed by the Human Rights Vision. Council of Europe, you have the floor.
Madam Moderator, Europe has been a de facto death penalty-free zone. This situation has largely come about due to the Council of Europe, which has been a pioneer in the abolition process. Death punishment is now regarded as an unacceptable form of punishment, incompatible with the fundamental rights, the right to life, and the right not to be subjected to cruel, inhuman, or degrading treatment. The Euro abolition of death penalty in all Council of Europe member states and in all circumstances remains a central political objective of the organization. Every 6 months, the Council of Europe Committee of Ministers debates the situation of the death penalty on the European continent and will continue to do so regularly until Europe has become a de jure death penalty-free zone. At those occasions, it considers information by and encourages those countries which have not yet ratified the protocols to the European Convention on Human Rights, which provide for the abolition of the death penalty. Madam Moderator, there has been a visible trend towards universal abolition of death penalty over the last years, reflected not only in the growing number of international and national legal instruments and norms, but also in an increasing recognition by governments and politicians that the death penalty has no place in a civilized democratic society. The global decline in a number of executions, however, contrasts with some setbacks and new worrying trends, illustrating the need to remain vigilant. Council of Europe regularly calls for the support of the UN General Assembly resolutions on the worldwide moratorium on the use of the death penalty and encourages member states to ratify the second optional protocol to ICCPR. Finally, the organization has also intervened in a number of individual cases with a view to drawing attention of national authorities to the need to respect international human rights standards. Thank you.
Thank you very much, and also thank you for respecting the time limit. I will now give the floor to Human Rights Vision, followed by the People's Assembly of Kyrgyzstan. Human Rights Vision, please.
Thank you, Madam Chair. Despite the fact that Tajikistan ratified the Convention Against Torture still remain one of the main methods used by law enforcement agencies of Tajikistan in their activities. Already during pre-trial investigation, the interrogations alternate tortures. Tortures include beatings by hands and legs of various parts of body, beating by rubber bludgeons and metal objects, undressing till nude and hours long standing in cold water, electric tortures, a stick of needles under nails, and other forms. The so-called machine LG device for generation of electric current is widely used. Tortures are followed by insults, humiliations, and threats, including towards family members. It should be especially noted that political prisoners in Tajikistan are subject to the toughest tortures. Tortures are applied to them even prior to indictment. Mohamed Ali Haid in his video message said that he was beaten by hands and legs starting from the pretrial detention center. Further, he said that beating, humiliations, and insults are a natural course of investigation, and all prisoners are subject to tortures. Detained lawyer Buzurgmehar Yorov was subject to beating first day of his arrest. That was testified by his clothes with blood signs that was sent to his relatives. We strongly urge Tajikistan authorities to create independent international commission for investigation of facts of application of tortures during the investigation in the pretrial detention center and in prisons, to start immediate investigations on tortures in relation to political prisoners and bring to responsibility of perpetrators. We appeal to all international organizations on human rights protection, OSCE, Committee of United Nations on Human Rights, to pay close attention and to enhance monitoring on fulfillment of duties by Tajikistan for their obligations according to International Covenant on Civil and Political Rights. The full version of our report will be, with detailed analysis and example, will be available on the website. Thank you.
Thank you very much. Now I have the People's Assembly of Kyrgyzstan, followed by the Austrian Ombudsman Board.
Good morning. Friends, I'd like to pick up on 3 points in particular with regard to torture. The governments of those countries fighting against terrorism need a high level of professional training doing the anti-terrorist work. If that's not the case, then that is compensated for by torture. Secondly, please remember that we're talking about terrorist ideology which believes in alienation, violence and killing. Countries fighting against terrorism have not developed a counter-ideology which would counter the radical, violent ideology of terrorism. Third question, which I think civilized countries and governments have lost sight of, is that we are losing the fight to socialize individuals in society, integrate them in society. In order for this to be done successfully, human beings need a good psychological development and education. They need not only academic education, but a good vocational education, a right to work, and decent work at that. They should have the right to self-development and finding themselves a place in society. Only if we remember these three key points will it be possible for civilized countries to beat terrorism. Otherwise, all initiatives will be lost. Thank you.
I will now give the floor to the Austrian Ombudsman Board, followed by the Delegation of Armenia. The Austrian Ombudsman Board.
Madam Chair, ladies and gentlemen, my name is Günther Kreuter. I am Austrian Ombudsman and General Secretary of the International Ombudsman Institute. I would like to talk about the OPCAT mandate, the development of expert skills, and draw your attention to the fact that the International Ombudsman Institute is hosting a very special NPM training next week. After 2 successful OPCAT trainings in Riga, Latvia in 2015 and Vilnius, Lithuania in 2016, when Riga a more general approach was taken and in Vilnius a focus was laid on visits in psychiatric clinics, the 3rd round of NPM training, which we will be hosting in Vienna, takes a special approach. With this innovative training seminar, the IOI strives to create a new format that enables participants to learn through a practical approach while at the same time upholding the do not harm principle, which is so essential when monitoring places of detention. How can we manage this challenge? Besides holding lectures on NPM issues, we will offer interactive role-play scenarios with professional trained actors to improve communication skills and techniques. They play dementia, post-traumatic disorder, borderline, alcoholic and forensic facilities, etc. Further, we will provide our participants with a live stream of a visit to 2 institutions, a nursing home and a facility that provides aftercare to former prison inmates, without disturbing them with a larger group of visitors. Members of the APT and the SPT will contribute to these sessions by adding their expertise. This will additionally enrich the overall experience of the training for all participants, who are mainly from Europe and Africa. Finally, ladies and gentlemen, I'm convinced that trainings, workshops and learnings from each other are the best ways to further NPM work in countries in Europe and around the world, which in turn serve the development of the OPCAT mandate and the protection and promotion of human rights. Thank you very much.
Thank you very much. I will now give the floor to the Delegation of Armenia, followed by Golos Svobody Public Foundation from Kyrgyzstan. Armenia, you have the floor.
Thank you, Madam Moderator. We welcome the opportunity to discuss the topic of prevention of torture and protection of human rights in context of fighting terrorism. And we thank the distinguished speakers for very thoughtful remarks. I would like to start with recommendations. First, international obligations on prevention of torture should apply throughout all phases of conflict cycle. Second, commitment of participating states to their obligations should be even stronger in times of crisis and conflicts. Third, OSCE participating states should allow access of UN specialized bodies and ICRC to conflict areas. And fourth, we attach highest importance to full and unrestrained access of the ICRC to places of detention and monitoring of conditions of captives in the context of conflicts. Unfortunately, situation in OSCE area is alarming. Some OSCE participating states do not allow access of ICRC and international members of international community to conflict areas with the aim to cover gross violations of international humanitarian law and cases of torture and other forms of inhuman degrading treatment. This is the case particularly with regard to the NK conflict. We have a number of times raised the issue of torture and mutilation of the bodies of servicemen of the Artsakh Defense Army and civilians killed during the April 2016 large-scale offensive of Azerbaijan against Artsakh. Comprehensive reports of the NK Ombudsman and other documents providing well-documented factual material on the atrocities committed against civilian population of the Talish village and torture of captive servicemen and mutilation of their bodies have been distributed in the OSCE. The perpetrators of these hate crimes were awarded by the highest leadership of Azerbaijan. Another pressing issue we would like to touch is dignified treatment of captive civilians, prisoners of war, and human remains. Number of cases of torture and killing of Armenian civilians happened in Azerbaijani custody, including cases of Mamikon Khojayan, Manvel Saribekyan, and Karen Petrosyan. Thank you, Madam Moderator.
Thank you. I now have Голос Свободы Public Foundation from Kyrgyzstan, followed by Союз Единения, also from Kyrgyzstan. Голос Свободы.
Благодарю.
Thank you very much, and good morning, participants. We'd like to give our view on the fundamental freedoms on the right of personal inviolability and right not to be tortured. We've carried out a report on people using narcotics and methadone, and we have some recommendations from our NGO, which would like the OSCE and the delegations to take into account. Firstly, promote state monitoring and controls on holding to account those who act illegally in interrogating, investigating and court cases. Secondly, develop standards limiting detention and limiting detention without sufficient basis and broaden liability for such acts. Thirdly, exclude evidence of detainees giving under conditions of drug withdrawal. And fourthly, make equivalent with torture under law the interrogation of a detainee under conditions of drug withdrawal without medical assistance. During the monitoring of the patients on methadone therapy, we received information on systematic violation by law enforcement agencies. Many patients reported that they were improperly detained and subjected to torture. 117 were questioned, 111 were subjected to torture, and many reported, 91 in fact, about extortion, and 75 said that drugs were planted on them by officers of the law enforcement agencies. Thank you for your attention.
I now have Союз Единения from Kyrgyzstan, followed by the Public Foundation Positive Dialogue, also from Kyrgyzstan. Союз Единения, пожалуйста.
Уважаемые
Ladies and gentlemen, following the most recent changes in the Kyrgyz constitution introduced in December of last year, now investigation of criminal cases based on claims or reports of torture will be the responsibility not of prosecution investigators, but rather investigators of the National Secret Service, namely the GKNB. Now, this can be both positive, but it is also risky. It is positive that GKNB investigators do not have the conflict of interest that prosecutors had, because they were simultaneously responsible for monitoring, investigating criminal cases, and prosecuting in court in the name of the state. Now, the main risks connected with this transfer of responsibility to GKNB investigators for torture cases are the following. This can be a deterrent for torture victims who perhaps would not be delighted to be in contact with the Secret Service. Second, the structure and the status of the GKNB means that they are not in a position, especially in remote areas, quickly to receive, register, and react to claims of torture. And they don't also necessarily have the expertise effectively to document the physical and psychological evidence of torture having occurred. Now, we believe that there can be ways of improving the effectiveness of torture investigation with a view to ensuring certainty of punishment for torture. First of all, to carry out an information campaign, as a result of which the GKNB will be seen by torture victims as an appropriate place to have torture cases investigated, because they are not necessarily secret in nature. Secondly, to change the structure and the status of the GKNB in order that it be in a position to ensure timely receipt, registration, and reaction to claims of torture, and that they be able to appoint court experts in accordance with the principles of the Istanbul Protocol. Third, to develop a sort of a manual for GKNB torture investigators in order that they be able to investigate cases of claims of torture in accordance with the principles of the Istanbul Protocol. Thank you for your attention.
Public Foundation Positive Dialogue from Kyrgyzstan, followed by the Delegation of France. Public Foundation Positive Dialogue, you have the floor.
Good morning. As individuals against torture, we would recommend to the authorities of Kyrgyzstan to include in the criminal code acts against individuals which run counter to the Convention Against Torture. It's necessary also to register all detainees and also register reports of torture. Also the provision of lawyers and ensure that women are protected in particular. At the moment, the Article 1 of the Convention Against Torture needs to be transposed into international law. The announcement, or rather the reports on torture do not fall under any particular provision, and it's necessary to further specify this. At the moment, we are seeing physical and psychological effects of detention on individuals. It is necessary to attribute specific status to these acts, as also necessary to ensure legal assistance. Many law enforcement agencies have, for example, electrical equipment that could be used for such ends. Quite often, lawyers are attributed without consent. It's necessary that lawyers support the interests of their clients, and particularly when it comes to identifying acts that could be considered as torture. The government also needs to take a gender-oriented approach to meet the specific needs of women in this context, as well as ensuring the provision of effective medical assistance. Thank you.
I now have the delegation of France, followed by the Azerbaijan Institute for Democracy and Human Rights. France, you have the floor.
Thank you. We support the declaration made on behalf of the European Union, but we'd like to add some points on a national basis. Over the last few decades, the application of capital punishment has declined around the world. We are nevertheless very concerned that there are some appeals for re-establishment of the death sentence in some participating states. We would like to remind everyone that there can be no pretext for the death sentence. There is no research, no study that establishes any correlation whatsoever between the maintenance or abolition of the death sentence and the development of criminality. The terrorist threat cannot be invoked to justify its application. You do not combat barbarity by copying it. Now, of course, combating drug traffic is not a justification either. All the human rights are universal, and in fact, there are countries in all continents, whatever their culture or their beliefs, that have abolished the death sentence. France appeals all states to still apply the death sentence to observe a moratorium and to reflect on this cruel, inhuman, ineffective punishment with a view to complete abolition. Given its mandate, the ODIHR has a very important role to play. Now, given the priority that it gives to combating impunity, France has been mobilized for more than 40 years against the practice of forced disappearance. This practice is still widespread and is spreading, in fact, in the OSCE area. It's a violation of human rights, which is often a first stage, followed by other violations of human rights. France calls on all participating states that have not yet done it to ratify the Forced Disappearance Convention and to recognize the competence of the Forced Disappearance Committee. It believes that in accordance with international law, there is an absolute interdiction of torture under all circumstances. We encourage participating states that have not yet done so to ratify the Convention Against Torture, as well as its optional protocol, which institutes national prevention mechanisms. Thank you.
The Azerbaijan Institute for Democracy and Human Rights to take the floor. We have just been informed that the representative of this organization would like to make his statement in Azeri language. Although it is not an OSCE language, we will allow it as an exception, and with the understanding that the speaker provided the text in English to our interpreters. Please bear in mind that in the case of this statement, the interpreters do not bear responsibility for the content or for the quality of the English version of the text. I now give the floor to the representative of the Azerbaijan Institute for Democracy and Human Rights, that will be followed by the CBC TV channel.
Thank you, Madam Moderator. My name is Ahmad Shahidov. I'm a human rights defender from Azerbaijan. My colleague will continue his speech in Azerbaijan. So today's topic is about fighting terrorism, human rights, and torture. So I built my today's speech on a concrete example. Over the last 3 years, we have talked about this issue at various OSCE meetings. Unfortunately, Armenia doesn't care about our calls to release these civilians, as does not comply with international commitments. I will ask Russian representative here to also to react this issue, because one of these persons is a citizen of Russia. I mean, these two persons, I ask all of you to pay attention to these older people on the photo. Shahbaz Guliyev and Dilgam Askarov were taken hostage by Armenian armed forces in July 14, and Shahbaz Guliyev was sentenced to 22 years, and Dilgam Askarov was sentenced to life imprisonment. Armenia presents these civilians as terrorists, and this young man sitting next to me is son of one of these hostages, Dilgam Askarov, who is in Armenian captivity now. And I want Dilgam Askarov's son to speak and talk about his father, and I ask our interpreters to look at the statement number 15. So, thank you.
I came here to say that there is no news from my father for the last 7 months, and the last time I received a letter from my father was in March of this year. He has serious health problems, severe pains in his heart, head and back. In 2014, my father went to visit his mother's grave in Kalbaya and was abducted by Armenian soldiers. At that time, my father was 95 kilograms, and now he is 45 kilograms. Our family is in a very bad state. We still do not know why they arrested my dad. He's committed no sin. My dad is sick, an old man. Our family is in a very bad situation, has been for the last 4 years. Each time when I get a letter from my father, we suffer a great deal of stress. All of you have children. In the evenings, you spend time with your kids. I also want to see my dad. I want to sit and talk with my father. I want my father to be with me on my birthdays. There are many diplomats and ambassadors here. You are discussing global issues. I ask you to help my father, Dilgam Askarov, to be released soon, because my father has no fault. Keeping innocent people in captivity is not right, and you know it well.
Thank you very much.
Thank you. I will now give the floor to the CBC TV channel, followed by the International Partnership for Human Rights. CBC TV channel, you have the floor. Do we have the CBC TV channel to speak? Okay, so let us move to International Partnership for Human Rights, and if the CBC TV channel returns, we will come back to you later.
Good afternoon, Yulia Ravitite from International Partnership for Human Rights. I am delivering the statement on behalf of the NGO coalitions against torture in Kazakhstan, Kyrgyzstan, and Tajikistan, the Association for Human Rights in Central Asia, the Turkmen Initiative for Human Rights, and the International Partnership for Human Rights. We acknowledge that the authorities of all Central Asian states have made some noteworthy positive steps in recent years, but a lot more has to be done to break the vicious circle of torture and impunity. Law enforcement officers in Central Asia continue to use torture and other forms of ill treatment, including electric shock, suffocation, rape, and beatings. Since January 2017, the NGO coalitions against torture have registered over 110 new cases of torture or ill treatment in Kazakhstan, over 75 in Kyrgyzstan, and over 35 in Tajikistan. These figures represent only the tip of the iceberg, as many victims and their relatives refrain from lodging complaints for fear of reprisals or because they do not believe they will attain justice. In Uzbekistan and Turkmenistan, torture is also widely used. Outside the plenary hall, you will find a written statement that provides an overview of the situation of torture in Central Asia and concludes with a set of recommendations to the relevant authorities. The paper pays special attention to the problems connected to lodging complaints about torture, concerns to do with the investigation, impunity, the lack of access to reparation, and the necessity to conduct independent monitoring of detention facilities. The paper highlights a number of individual cases aiming to draw international attention and encourage respective country authorities to investigate them. Among the cases, you will find that of Yusuf Mohamed Ogleperigam from Kyrgyzstan, whose allegations of torture have not been effectively investigated for over 2 years. You'll also find a case of Umar Babajanov, who died in custody in Tajikistan under suspicious circumstances. The case of 18 men who were caught up in the anti-Gulen crackdown in Turkmenistan and who were allegedly beaten and held naked in darkened rooms for long periods. And finally, a short account of a former prisoner in Uzbekistan about torture in places of detention. I thank you for your attention.
Thank you. Do we now have the CBC TV channel representative? No. Then next on my list is the regional Bulgarian National Cultural Autonomy of the Republic of Crimea, named after Paisi Hilendarsky. I think the representative of this organization is not at the speaker's table. Then I have the Association of Religious Organizations of Kazakhstan, AROK.
Thank you, Madam Moderator. My name is Alexander Khrushchev, and I'm a representative of the Association of Religious Organizations of Kazakhstan. I'd like to note that respect for the rule of law and for human rights is one of the key aspects of any international effort to combat terrorism. The effectiveness of anti-terrorist measures depends directly on international law and respect for human rights. The state must make sure that it puts in place appropriate mechanisms to combat terrorism that are fully respectful of human rights. One of the conditions of the spreading of terrorism, inter alia, is non-respect for human rights, religious discrimination, and also a lack of rule of law. Now, the global fight against terrorism is counterproductive if it does not include respect for human rights. The recruitment by international terrorist groups of new adherents is facilitated by violations of human rights, which results in people feeling a loss of dignity. It's very important that we organize seminars and training courses for the representatives of the forces of law and order and other state representatives who are responsible for combating terrorism, in order to show them how important it is and how responsible they are for respecting human rights in the combating of terrorism. Today, we note, unfortunately, that in a number of countries, the number of those who are victims of fabricated investigations and unfair trials in connection with the combating of terrorism. Now, this results in suffering not only for them, but also their loved ones. We need very carefully to take into consideration victims of violations of human rights or of religious discrimination. Within the framework of their counterterrorism strategy, the OSCE participating states should be fully respectful of human rights. That really is at the very foundation of combating terrorism. Strengthening and stimulating the protection of human rights at the state level is an indispensable aspect of combating terrorism, and the full statement will be available on the site. Thank you.
National Information Agency, followed by the Delegation of Kyrgyzstan. Россия сегодня.
Colleagues, Veronika Krishnenika, I'm an advisor of the information agency Россия сегодня. A number of violations of human rights have already been addressed. They have become normal in the global war against terrorism. To this long, tragic list, we can add the practice of secret prisons on the territory of other states. The secret CIA prisons have been working in countries from Latvia, Poland, Morocco, Saudi Arabia, but these are mere local events when compared to the tragedy which has been visited on the Middle East by the United States. The global war against terrorism began in Afghanistan in 2001, then it led to chaos in Iraq, Libya, then Syria. And there is a plan underway to do the same thing in Iran. The wave of violence has spread throughout the whole region of Middle East and North Africa. So let's ask a simple question. After 16 years of the war against terrorism, which the US and its allies have been waging, are there more or less supporters of terrorism? Has the land under the control of terrorists increased or decreased in 16 years? Have we seen Washington repeat the same mistake time and again, or is it indeed a mistake? Maybe it's an intentional policy. The instrument in Syria for the United States has been the Syrian Democratic Forces. Now, this is what General Raymond Thomas said about them. They call themselves the YPG, which means the Working Party of Kyrgyzstan, which has been recognized as a terrorist organization by the State Department itself. So we said to the Kurds, change your brand. And after a few days, they changed their name, calling themselves the Syrian Democratic Forces. Now, and then the general said, isn't it surprising that they've turned to democracy in only a few days? In that way, terrorist forces have become democratic forces in only a few days. So the effects are not limited in the Middle East. Refugees are having to leave their country, coming to Europe to be subjected to new forms of distress. I'm coming to the end. And they are subjected to the consequences of these wars. So we welcome the efforts of the organization to supervise or oversee the rights of refugees. We believe that all humans are born equal and should enjoy the same rights. And my closing sentence now, I will do that. We understand that unlike states, many citizens of the US categorically disagree with the misguided decisions and the failure to comply with international law. We are willing to work on this basis and within the context of international organizations and international law. Thank you.
Followed by the Protection of Rights Without Borders Agency. And I would like to again encourage all speakers to stick to the time limit of 2 minutes. Thank you.
Thank you, Madam Moderator. My name is Nadir Horry, and I'm responsible for the National Prevention Mechanism of Kyrgyzstan. Ladies and gentlemen, I would like to share a few comments with you about the situation when it comes to prevention of torture in Kyrgyzstan. First of all, let me draw your attention to the fact that while we recognize the problem of torture, the authorities at the very highest level have adopted a number of serious measures to combat torture. One of them is the setting up of a national prevention mechanism within the Republic, which is very much in line with the optional protocol to the Convention to Prevent Torture. Now, the National Center to Prevent Torture has carried out more than 3,000 impromptu, unannounced visits to places of detention. We have investigated several hundred complaints of torture, and that has resulted in a number of prosecutions. 29 criminal cases have in fact been opened, and over the last 3 years, More than 80% of torture cases have been brought against employees of the security service, the forces of law and order in general, and there has been some identification of these cases, and so we have managed to develop a very reliable database. And now the Prosecutor General, on the basis of the recommendation of our center, opened a special unit for the investigation of claims of torture. At the present time, we are looking at the possibility of setting up such units within the regional prosecutor's office as well. So there is an overall trend that is positive, but the problem of torture is still in place in Kyrgyzstan, and we think it's a topical issue that we must continue to combat.
Borders Agency, followed by Kazakhstan International Bureau for Human Rights and Rule of Law, Pavlodar Regional Branch, Protection of Rights Without Borders.
Thank you, Madam Moderator. I'm Arax Melkonyan from Protection of Rights Without Borders NGO, and I would like to address some torture-related issues in Armenia. Although the definition of torture as criminal offense has been amended in our criminal code, applying to the violent acts of officials conducting in their official capacities, it does not include acts of ill-treatment, and in practice, the acts of torture and ill-treatment are not being properly qualified and effectively investigated by law enforcement officers. Rather, these acts are qualified as abuse of force, and which does not guarantee justice and redress, including compensation and rehabilitation for torture victims under our domestic legislation. Statistics show that after the amendment in the criminal code, no case of torture has been transferred to domestic courts with indictment. It's very much concerning that no effective investigation of the large-scale police misconduct during peaceful assemblies and demonstrations from last year's July events took place, when the police officers and civilians affiliated to police beat ill-treated demonstrators and journalists in public and while in detention using different equipments and physical and psychological abuse. More than 1 year after those events, pre-trial investigation is still pending and no police officer is in charge in any crime, notwithstanding the amount of existing evidence against them. The authorities only sacked Yerevan police chief and reprimanded several police officers. In this regard, from 1st of August last year, 2016, the president of Armenia, Serge Sargsyan, expressed his gratitude to the representatives of law enforcement for their excellent work. Moreover, he called journalists to forget about the events and awarded our police chief and riot police chief for their excellent maintenance of public order. These acts of head of state clearly show that there is tolerance and moreover support for the police brutality, and the public authorities in this regard cannot be considered as independent for investigation. This tolerance and support leads to more crime, and one of the unprecedented recent crimes has been conducted on June 28th this year, when 5 members of Sasnatrej group have been beaten, ill-treated in court facilities. This is unprecedented for Armenia. Again, the criminal case has been initiated under the heading of abuse of power, but the police officers continue to transfer those people from remand prison to court and continue to threaten them, as was stated by their lawyers. In this respect, we urge, just conclusions, I'm sorry. In this respect, we urge Armenian authorities to conduct thorough and independent, effective investigation and calls all international human rights organizations, OSCE, ODIHR, and UN Human Rights Committee, also Convention Against Torture, to pay close attention to those investigations. Thank you very much.
Thank you. Now the Kazakhstan International Bureau for Human Rights and Rule of Law, Pavlodar Regional Branch, followed by Amnesty International.
Good morning, colleagues. I'd like to raise a couple of cases out of many this morning related to torture. On 25th February 2016, 3 days before the release, the 5-time champion of judo of Kazakhstan, Abdulkarim of Kazakhstan, died after being injured, including having 150 cuts. The time of death was recorded as being 7 o'clock in the morning, but that cannot be right because there was evidence that in the evening after that time he was still alive. For 3 days, it turned out he had been subject to torture, and the evidence was not given by the authorities, and the conclusion that was put forward was that it was a case of suicide. However, this didn't hold up. It was alleged that he had committed suicide by cutting himself in the neck, but witnesses showed or testified that this was not the case. Others said that he had been beaten by officers. As a result, the witnesses who were making such testimony were threatened. One of them had contacted an NGO, but was subsequently beaten as a result. That's the first case. The second case of the 16th of September 2015, Barujan Azorov was late for a court showing and was at the moment of entering the court at the turnstile was taken by the police. He was confined to a room and subjected to violent acts. The acts resulted in major suffering. He was subjected to what's known as the swallow. His hands were cuffed behind his back and his neck pulled back for long periods of time. It is only the intervention of international human rights organizations which have prompted the public prosecutor to look into this. However, there's been no action. There has not been sufficient action. The conclusion on the cases is that the law enforcement agencies have a large number of individuals who are willing to subject others to humiliating and violent acts and ignore the law. So the recommendation that we would make is that the Ministry of Internal Affairs be subjected to significant review. Thank you.
Floor to Amnesty International, followed by the human rights movement Birduino from Kyrgyzstan.
Thank you, Madam Moderator. This year sees the 40th anniversary of Amnesty International's work on the death penalty. In that time, nearly 2/3 of the world's countries have abolished the death penalty in either law or practice. The trend towards abolition is by now irreversible and global. In the whole of Europe and Central Asia, no country applies the death penalty except for one. That country not only continues to issue death sentences, but is actively executing prisoners. That country is Belarus. In 2016, at least 4 men were executed and 4 death sentences were handed down. Already in 2017, 1 man has been executed and 3 further death sentences have been issued. The statistics stand in stark contrast to the rhetoric of the Belarusian authorities, which has increasingly acknowledged the inevitability of abolition. Only last year, the chairman of the Permanent Commission for International Affairs and National Security of the Council of the Republic, Yeladze Misianko, declared at an international conference on the death penalty in Belarus that the abolition of the death penalty is a historic inevitability and an important European trend, which we will join sooner or later. There is no later in this matter of life and death. The time is now. It is also inconceivable that such positive statements are made while executions continue to take place unabated. particularly cynical was the execution of 3 out of 4 men on death row in November 2016, only weeks before Belarus hosted its second international conference on the death penalty that year. Death sentences are often imposed in Belarus after unfair trials, which included forced confessions. They are implemented in strict secrecy and without giving adequate notice to the condemned prisoners themselves, their families, or legal representatives. Prisoners are told that their plea for clemency has been denied only moments before being led into the execution chamber, forced to their knees, and shot in the back of the head. The authorities refuse to return the bodies of those executed to their families or even tell them where they are buried. More cynically still, executions are carried out despite requests from the UN Human Rights Committee to the government of Belarus not to do so until the committee has considered the cases. Belarus has no excuses for continuing this barbaric practice, which constitutes the ultimate cruel, inhumane, and degrading punishment and a violation of the right to life. Belarus must introduce an immediate moratorium on death sentences with a view to abolishing the death penalty. Thank you.
Thank you. Before I give the floor to the next speaker, allow me to introduce that our death penalty in the OSCE area background paper 2017 will be uploaded on our website within the coming hour, and its thematic focus for this year is children of parents sentenced to death or executed. And I will now give the floor to the human rights movement Birtuino from Kyrgyzstan, followed by the delegation of Spain. Birtuino, you have the floor.
Thank you. Yeah, the wife of a Kyrgyzstan human rights defender, Mr. Askarov, distinguished chair of this important session. For more than 8 years, our family has been awaiting justice. We're awaiting the day when my husband will finally be released so that we can once again be together. To our great regret, he has been left languishing in prison despite the call by the UN committee immediately to release him. It's difficult for me to describe all of the horror and pain that we have experienced over these years, during which my husband has been beaten and tortured by police officers. And they have tried to isolate me from the world, keep me from meeting colleagues of my husband and representatives of international organizations. To this day, whenever someone comes to visit me, that person is then jailed. There has been illegal confiscation of our home as a further repressive measure, flouting all legal standards. So I would appeal to all of you to take the necessary measures, at least on a humanitarian basis, to release my husband. Now, Mr. Atambayev, the president of Kyrgyzstan, is at present at the UN, and I hope that he will implement the decision of the UN committee to release my husband. And I think it is also important to remind the international community that there are dozens of unfairly charged, accused, and sentenced persons in my country who have not had the possibility to defend themselves in court on fear of torture. And there are many thousands of our fellow citizens who, after June of 2010, have been chased from their homes, and they are waiting for the day when they can return to the country without fear of detention, arrest, and torture. So once again, in the name of my husband, Mr. Askarov, and in my own name, my entire family and my organization, I express sincere thanks to all those who over these difficult years have remained by our side. Thank you.
Much. Maybe I will just add that we are grateful to the government of Kyrgyzstan that until several years ago allowed ODIHR to visit Mr. Askarov in the place of detention. I will now give the floor to the delegation of Spain, followed by the Committee Against Torture. Spain, you have the floor.
Thank you. España se alinea.
Spain would line itself completely with the statement made by Denmark on behalf of the European Union, but would like to make the following statement. Despite the absolute prohibition of torture in international law, as well as degrading human treatment, we still see some practices in the OSCE area, and we roundly condemn this. We fully support the initiative of the Convention Against Torture, which seeks to achieve universal ratification and application by 2024, and encourage all participating states to ratify the Convention and its optional protocol. Death penalty. Spain is firmly against the death penalty and has made campaigning against the death penalty one of its priorities in foreign policy. We reject the death penalty regardless of the severity of the crime committed. It is a severe punishment with irreparable effects, and it does not serve as a deterrent. We have participated in 2010 in the creation of the International Commission Against the Death Penalty. And finally, with regard to the protection of human rights and fighting against terrorism, the regulation of human rights allows countries to protect their citizens from terrorism. Behavior such as glorification of terrorism, as Mr. Nadir Horry referred to, is something that I will come back to in my right to reply. All this can be done scrupulously respecting human rights. I would remind Nadir Horry that you referred to the Basque group as you refer to it quite lightly, but in fact this is a terrorist group which has caused the death of 829 people, including women and children, in more than 40 years of terrorist activities. Thank you.
Thank you. I will now give the floor to the Committee Against Torture, followed by the Public Verdict Foundation. Committee Against Torture, you have the floor.
Thank you, Madam Moderator. Despite being accorded high priority by the international community, the fight against impunity for torture remains a challenge, especially in the light of recent negative dynamics in the human rights sphere, such as shrinking space for civil society and pressure on human rights defenders in Russia. While impunity often reaches appalling levels, fighting it requires a multidimensional approach. Indeed, civil society organizations operate within a framework of international, regional, and domestic legislation and standards that promote a holistic approach to the fight against torture. For many years, my organization was addressing torture issues at human dimension implementation meetings and trying to attract attention to the impunity of the perpetrators, lack of effective investigations of torture crimes, and more intensive elimination of information about tortures and abductions flowing from the republics of North Caucasus, especially from Chechnya. But for the recent years, we started to witness that other OSCE countries started to participate in putting people to threat of torture and abduction more actively. Only this year, we have witnessed a number of cases of illegal expulsion of torture victims from Republic of Belarus to Russia on fake accusations that were supported by Interpol search warrants. Namely, Murad Amriyev, mixed martial arts champion who was subjected to severe tortures in Chechnya, then left Russia and was living in Ukraine legally, was arrested in Belarus and illegally expelled to Russia, despite the full pack of evidences presented to Belarusian authorities about risk to be subjected to torture again. International human rights law explicitly requires that perpetrators of torture and cruel, inhuman, and degrading treatment or punishment are held accountable. Moreover, it requires that people cannot be put at risk of torture and expelled to the country where a risk to be tortured is proved by sufficient evidences. However, despite clear obligations to investigate and prosecute allegations of torture and concerted efforts to achieve implementation, torture remains pervasive in my country, and impunity of perpetrators is widespread, which contributes to a vicious cycle of violence. At the same time, no adequate reaction from the international authorities towards illegal expulsions of potential torture victims encouraged development of torture practices in OSCE region. Thank you.
Thank you very much. I now have Public Verdict Foundation, followed by the Institute for Reporters' Freedom and Safety. Public Verdict Foundation, you have the floor.
Thank you, Madam Moderator. Torture continues to be among the worst human rights violations in many OSCE participating states. In some countries and regions, torture is widespread and systematic and is practiced with impunity. Prosecution rates against perpetrators are shamefully low, which also proves the systematic nature of torture in many contexts. Civil society actors believe that OSCE participating states, political bodies and institutions should do much more to address this major problem. On behalf of Civil Solidarity Platform, wide coalition of about 90 human rights NGOs working across OSCE region, I would like to highlight the most important recommendations elaborated by the platform. Our recommendations to the OSCE. OSCE should ensure that torture prevention is a priority for the organization, building on the work of Swiss chairmanship in 2014 and ODIHR since then, and using civil society recommendations. The OSCE should ensure the preparation of updated OSCE commitments on eradicating torture, which should address new challenges and include enforced disappearance as a form of grave human rights violations and torture. OSCE should continue to support the work of a focal point on torture prevention and establish expert panel on combating torture. The panel should meet regularly and to assess relevant laws and practices in participating states, monitor progress, give advice to participating states on implementation of their commitments on the eradication of torture. Our recommendations to the member states. States should ensure the effective investigations into all cases of torture or ill treatment and bring the perpetrators to justice. States should guarantee access to an alternative forensic examination for any alleged victims of torture and ill treatment and ensure that the funding of such examinations carry equal weight under domestic procedural legislation. States should ensure that work of doctors and other medical personnel in detention facilities are truly independent. States should ensure that adequate medical services are available to all detainees at all times and that medical personnel working inside detention facilities are trained on application of the provisions of Istanbul Protocol. And we invite you at our site event at room 1 during the lunchtime where members of the platform will provide more information on the situation of this torture in the region. Thank you.
Thank you very much. I will now invite the Institute for Reporters' Freedom and Safety, followed by the Crimean Human Rights Group, the Institute for Reporters' Freedom and Safety. Okay, since the Institute for Reporters' Freedom and Safety doesn't seem to be present, I will give the floor to Crimean Human Rights Group.
Ladies and gentlemen, thank you for the opportunity to tell you about the situation with tortures in Crimea, which continues to deteriorate steadily since the Russian occupation. It's reliably known about the use of torture in politically motivated cases against such Ukrainian citizens as Kostenko, Kolomyys, Panov, Zakhtey, Prisich, and many, many others. Thus, all attempts made by the lawyers to initiate the investigation of torture were completely ignored by the Russian authorities. According to our calculations, more than 60 people have been persecuted in Crimea for their political position and Ukrainian identity. Last week in Crimea there was another indicative case. Renat Paralamov was abducted by FSB from his own house. For more than a day his location was unknown. After cruel torture, Paralamov had to sign testimony against himself and other people, and then he was just thrown out at a bus station. This situation became possible because of the annexation of Crimea. The problem is that the Russian Federation regards the peninsula as its own territory and it doesn't recognize the mandate of international organization to work in Crimea as part of Ukraine. As a result, victims are deprived of standard international mechanism for protection against torture. For example, the United Nations Committee Against Torture, the Council of Europe Anti-Torture Committee, the United Nations Monitoring Mission in Ukraine cannot visit Crimea. Under such conditions, torture and cruel treatment have become common practice used by the police and the FSB. Victims tell about cruel tortures, including the usage of electricity and sexual violence. It should also be noted that the treatment and conditions of detention in penitentiary establishments in Crimea are cruel, inhuman, and degrading. We know about convicts who were tortured for refusing from the Russian citizenship. We know about the facts of denial in medical assistance and even death of convicted citizens of Ukraine who were transferred to Russian territory from Crimea. We demand that Russian authorities stop the use of torture, conduct an effective investigation, and bring to justice those who are responsible for the use of torture. Immediately release all political prisoners, let the international organizations to work in Crimea and ensure free access of the Ukrainian Ombudsman to the Ukrainian citizens in Crimea without any political conditions. Thank you.
Thank you. I will now give the floor to the Helsinki Foundation for Human Rights, followed by the Open Dialogue Foundation. The Helsinki Foundation for Human Rights, you have the floor.
Добрый день, уважаемые.
Dear colleagues, I think it's very important that I share some facts with you that we have obtained from our Ukrainian colleagues. This has to do with the torture and degrading treatment that takes place in the occupied territory of Crimea, occupied by the Russian Federation. Just 1 week ago, an inhabitant of the village of Persilogorsk gave me the information about a situation of using electrocution of the genitals and beating of the legs. These were individuals who were detained illegally without charge for several hours, and finally they managed to escape the territory and flee. There is a growing tendency of inhumane treatment at places of detention in Crimea. There is no medical care provided. The sanitary conditions are deplorable, and there is torture practiced. Because of this, many prisoners fall ill, and then they are not treated. There is also torture applied to members of a family when one person in the family is not seen with a kind eye by the authorities. And I would like to draw your attention to the fact that in occupied Crimea there has been no investigation of cases of torture, there has been no prosecution, and no charges have been brought. So we call on the Russian authorities to bring an end to these practices and to cease practicing torture in Crimea.
By the Delegation of Uzbekistan, the Open Dialogue Foundation.
Thank you very much. I'm Open Dialogue Foundation, sorry.
I would like to draw your attention to the unacceptable practice when Russia and Kazakhstan regularly use tortures, including not providing the medical aid, medicine to get false confessions. In case of Kazakhstan, I would like to mention the case of political prisoner Mukhtar Drakishev. Drakishev is kept as a hostage by Nazarbayev regime and was sentenced for 14 years because Drakishev refused to sign false confessions against opposition politician Mukhtar Ablyazov and his friendship. Due to excessively high blood pressure, Drakishev at a constant risk of stroke and ischemia. During 8 years of his detention, Drakishev was beaten, after which he developed kidney disease. Currently, Drakishev needs urgent hospitalization in a public clinic, but he doesn't receive the necessary medical care in a penal institution. As a consequence, his state of health situation may even lead to his death. The UN Human Rights Committee demanded that the judgment of Kazakhstan authorities be revoked and Drakishev to be released from prison. But Kazakhstan refused to comply with the decision of the UN Committee and once again showed disrespect for his international obligation. Russia have just recently organized kidnapping of 19-year-old Ukrainian citizen. Pavel Grib has become another victim of Russian hybrid war against Ukraine. Since the beginning of the Russian-Ukraine conflict, approximately 70 Ukrainian citizens has faced politically motivated motivated criminal proceedings in Russia, as well as in occupied Crimea. Russia brings various charges against Ukrainian: terrorism, extremism, espionage, the murders of Russian citizens, thus using them for the purpose of anti-Ukrainian military propaganda. The European Court of Human Rights demanded that the Russian government send medical documentation on Grip's current health condition, including the list of the medicines he has been receiving, before September 25. However, till now, Grip was not provided any medicine at all. Under the condition of the Russian detention facility without the necessary medical care, Grip's life is in immediate danger. The Open Dialogue Foundation considers it necessary for OSCE states to apply personal sanctions list for Russian and Kazakhstani officials who are responsible for systematic violation of international obligation and with premeditation use tortures and politically motivated persecution. Such campaigns as a list of Magnitsky, Let My People Go lists of sanctions, it is the only effective measure to stop and prevent impunity. Thank you.
Thank you very much. I will now give the floor to the delegation of Uzbekistan, followed by Cage Advocacy. Uzbekistan.
Madam Moderator, ladies and gentlemen, Visnov Makhimova, I'm representative of the Public Prosecutor of Kazakhstan. I'd like to focus briefly on the fundamental points of implementing a new policy in Uzbekistan to fight terrorism and prevent radicalization. Firstly, the President of the Republic of Uzbekistan has introduced a strategy plan with 5 priorities for the development of the Republic of Uzbekistan from 2017 to 2021, and that includes strengthening the organizations responsible for countering terrorism, religious extremism, and other forms of organized crime. Secondly, the creation of a multifaceted strategy to prevent the young from radicalization, strengthening the role of the young in politics and protecting them from violent influence. The creation of a organization for youth, and we're working to protect youth rights and promote their health and healthy lifestyle. Thirdly, a general humanistic spirit of Islam, and the promotion of that has involved the creation of an organization to dispel ignorance in the religious circles. Fourthly, counter extremism with a better, well-argued ideology based on genuine Islamic values and knowledge. The President of Uzbekistan has initiated this process, promoting a study center so that we can recognize the huge contribution of our forefathers, not only to knowledge in the context of Islam, but general enlightenment. Fifthly, ensure that those who feel marginalized in society do not fall prey to extremist influences. We have developed a list of extremists who have been identified. We've also focused on those who are vulnerable to such extremism, making sure that they find their place in society. A number of them have found work, and we have also been strengthening international cooperation, taking consequential measures to avoid the double standards and the full respect of international law. Thank you.
Thank you very much. I have been asked by our wonderful interpreters to ask participants to speak slowly, but at the same time, I have announced that participants have 2 minutes to make their statements. So if I could just recommend to start with recommendations so that they are not lost, and distribute your statements through the Documents Distribution Center. I will now give the floor to Cage Advocacy, followed by Justice and Liberties for All Committee.
To speak in this auditorium. I hope you've all had a pleasant, trouble-free experience. I landed yesterday night, but I wasn't allowed onto the plane without first being interrogated by 3 UK counterterrorism officers. Sadly, this isn't the first time, and sadly, I'm not alone in this experience. Each year, around 50,000 people on average are interrogated in the same way in my country. I am Mohamed Rabbani, the International Director of the legal rights NGO Cage, based in London. Next week, I am due to stand trial for refusing to hand over passwords to my electrical devices at the airport. I have not been suspected of a crime, nor have I been accused of any. Yet, I am being threatened with 3 months in prison for seeking to protect confidential information. Confidential information in a torture abuse case that implicates the US government. I have only 3 points to share. Firstly, the border power that I was held under is called Schedule 7. It is an example of how the balance between national security and commitment to human rights is totally misaligned. The UK delegation to OSCE sent a tweet today with a nice graphic talking about the rule of law. But it's not truthful, as the UK has been operating several powers that function outside of the rule of law for many years. Schedule 7 is a stop and search power used to collect mass intelligence on citizens. You can be stopped and searched without the need for any suspicion of any criminal activity and held for 6 hours without the right to remain silent. Even children can be interrogated under these powers. Secondly, such an unwieldy and draconian piece of legislation is actually only one example of an underlying logic which is characterized by pre-crime inconsistency with the rule of law, discriminatory application, disproportionate force, and counterproductive outcomes. The state has a responsibility to keep its citizens safe and secure. However, Schedule 7, coupled with prevent, operate on the premise of these notions. The role of states intruding on the private life of citizens has always been contentious. States will always want to consolidate more and more power, thus eroding power from their citizens. Lastly, I must say that there must be security and privacy, security and digital rights, security and freedoms. Most importantly, there must be respect for the rule of law. Next week, I, Mohamed Rabbani, may be sent to prison for my belief in the right to privacy and source protection. I urge all member states and policymakers to think about where we have reached as a society when an innocent man can be sent to prison for a password. There must be more than meetings and conferences. Commitment to action is what will make a difference. Thank you.
Thank you. I will now give the floor to Justice and Liberties for All Committee, followed by the Delegation of Ukraine.
The so-called war on terror is a disaster, yet nobody is questioning it. In the wake of the November 2015 terrorist attacks against my city, Paris, the French government, along with its allies, retaliated by sending bombers to Syria and Iraq. Later, we learned that a hospital had been bombed in the city of Manbij, Syria. How in the world can we pretend to protect civilian lives at home by destroying those abroad? I just heard statements against capital punishment and extrajudicial killings. We truly appreciate that. Yet, how do you explain that the former president of France, François Hollande, admits to having a kill list being submitted to him by the foreign intelligence? If governments fail to question decades of disastrous foreign policy, then our meetings here are just a waste of time. At home, I cannot think of a single so-called Western government that has not engaged in violating human rights and civil liberties in the name of fighting terrorism. Terrorism cannot be fought through warrantless house raids, the ransacking of mosques, Muslim-owned businesses, intimidating community leaders, as is the case of Mohamed Rabbani, Abdelaziz Chambi in France, imprisoning citizens on fallacious charges, as is the case for Hassan Diab, or by joining civilians. And if the effects of the war on terror are invisible to you, just take a look at Guantanamo. I am certain that policymakers are smart and well-informed, but if they lack courage to stand for human rights and the rule of law, then they can find strength and courage by truly engaging and partnering with civil society and accept to be challenged. Terrorist attacks happen even in dictatorships, and taking the path to becoming a police state will not make people any safer unless we speak about those in power. The JLC recommends, therefore, that the OSCE engages with governments and assesses their counterterrorism measures according to its own guidelines and take the dust off this book. It's been made available to the public, and I strongly urge you to read it and apply what has been written in it. Thank you very much.
Thank you. I will now give the floor to the Delegation of Ukraine, followed by the National Bar Association of the Republic of Moldova. Ukraine, you have the floor.
Madam Chair, Ukraine remains committed to preventing torture and punishing those who are responsible for it worldwide, and urges all OSCE states to ratify the optional protocol to the Convention Against Torture and establish an effective national prevention mechanism. Ukraine has an effective national prevention mechanism. It reacts to all cases of torture and cooperates with United Nations and Council of Europe committees on prevention of torture. Whenever such cases of torture or ill treatment are discovered, we are acting swiftly to investigate them. However, we are concerned about the climate of fear and lawlessness that Russian aggression brought to Crimea and Donbass. Russian-led terrorists in Donbass use torture as a means of intimidation of the population, silencing opposition and erasing Ukrainian cultural identity. United Nations Human Rights Monitoring Mission and ICRC are denied access to places of deprivation of liberty despite repeated requests. Parallel structures established in Donbass cannot guarantee any justice to victims of enforced disappearances, sexual violence and torture. In Crimea, Russia spread its domestic policies of intimidation and uses torture as a policy instrument to quash opposition, erase Ukrainian and Crimean Tatar cultural identity, and specifically targets Crimean Tatars and Ukrainians. Most recent cases of abduction and torture are that of Rinat Paralamov and Pavlo Grib, both performed by the Russian Secret Service, FSB. We call upon Russia to cease its domestic policies of intimidation, abduction and torture in Russia and occupied Crimea and Donbass. We also call upon international human rights monitoring bodies to establish a permanent presence in Crimea and Donbass. We call upon states and international organizations to introduce or prolong specific personal sanctions for human rights violations committed by Russia in Crimea and elsewhere. In the end, I would like to remark that if Russia wants to contribute to the worldwide fight against terrorism, it can start by ceasing to finance terrorism in Donbass. That would be a welcome step in the right direction. Thank you.
Thank you very much. I will now give the floor to the National Bar Association of the Republic of Moldova, followed by the Delegation of Georgia, the Bar Association of Moldova.
Добрый день, дамы и господа.
Good morning, ladies and gentlemen. Anna Orsaki, and I am a representative of the Moldovan National Bar Association. I'm a lawyer, I'm a human rights defender, and I'm from a country that has signed an association agreement with the EU 3 years ago, but unfortunately there have been no reforms introduced to combat torture. Now, since our colleagues from Promolex have already submitted a detailed written report about how the reform to combat torture has failed and have provided evidence of that, I'm not going to share the statistics with you. You can read all of this. Let me just refer briefly to one case, namely the death of a 31-year-old who was detained supposedly for insulting police officers, and 10 days later, after being kept in the cold, tortured and beaten, he died. He died simply because he supposedly insulted the individual. Now, an investigation into the death of this individual has not been closed yet. No charges have been brought. Now, unfortunately, in 2017, there have already been 26 such cases of deaths in detention, and that means that we must appeal to the international community to put pressure on the Republic of Moldova that is not fulfilling the commitments that it entered into in the association agreement signed with the EU 3 years ago. Now, insofar as terrorism is concerned, I might just briefly mention how manipulation of this can undermine human rights in Moldova. I'm referring in particular to a protest of yesterday, a protest action that was carried out by opposition political parties against the regime, which is controlled by our friendly neighborhood oligarch. Tear gas was used against women and children, and in order to conceal this fact, the propaganda machine of the regime has claimed that supposedly a bus that came with microphones and other equipment to be used in the protest was in fact, a threat, and that this was a group of terrorists who were going to blow up the whole protest march. And so they used our natural fear of terrorism to manipulate public opinion, and the so-called fight against terrorism can be used to conceal cases of abuse and torture against peace-loving citizens. Thank you.
Of Georgia to take the floor, and it will be followed by the Tokmadi media. Georgia, you have the floor.
Thank you, Madam Moderator. Torture and ill-treatment were systemic issues in Georgian prisons until 2012. Since the new government came into power, multifaceted measures were taken aiming at combating torture and ill-treatment. As a UN Special Rapporteur, Mr. Juan Mendes rightly observed in his report and reaffirmed by the Public Defender's Office, torture is no longer a systemic issue in Georgia. Significant diminution of prison population and improving of health conditions mark as another point of departure. Notably, in the European Court of Human Rights, Georgia reached friendly settlements and made unilateral declarations with regard to about 80 applications under Article 3 of the Convention. All of those applications being relating to the facts having taken place before November 2012. The Georgian legal framework, which explicitly criminalized torture, ensures independent and effective investigation of all facts of torture and ill-treatment. All facts of alleged torture is the subject of immediate and thorough investigation conducted by the competent authorities, law enforcement authorities. We also pay particular attention to the effective tools of coordination and monitoring of anti-torture activities. In this respect, the role of Interagency Anti-Torture Coordination Council, chaired by the Minister of Justice, should be noted, which brings together all stakeholders, including the civil society organizations, and continues to adopt efficient measures to prevent and prosecute the cases of ill treatment and provide prompt protection to the victims. Cooperation with and strengthening the role of national preventive mechanism remains one of the main topics for the government of Georgia. In conclusion, I have to reiterate that fight against torture remains one of the priority for the Georgian government, both by means of improving methods of prevention and prosecution and enhancing protection of the victims. Thank you.
Thank you very much. I will now give the floor to Tokmadi Media, followed by the representative of the Anti-Terrorism Unit of the OSCE.
Good afternoon. My name is Jamila Imbetova. I'm a journalist and mother of 2 children. My husband, Kazakhstan's prominent businessman, Muradkhan Tokmadi, became victim of politically motivated prosecution issued by Kazakh authorities in case of Mukhtar Ablazov. Having this aim, on 12th of June 2017, Kazakh authorities arrested my husband, Muradkhan Tokmadi, on charges of extortion allegedly committed 20 years ago. In the detention facility, special services demanded from my husband to confess about killing in early 2004 the banker Gerjan Tatishev allegedly at the instruction of Mukhtar Ablazov. My husband refused to give the testimony convenient to the investigative bodies. He didn't ever met Ablazov. After that, 2 more criminal cases were initiated against Muradkhan on charges of possession of weapons and another murder committed 90 years ago. The basis of the allegation of the assassination of Mr. Tatishev were the testimony of our distant relative. Looking at his current state of health, we understood that special services tortured him. The investigators said that they will create unbearable conditions of detention for my husband, will arrest me and other members of our family if he refused to give the convenient testimony. On 30 July, I reported through the social media that on my husband's body there are signs of torture. Still, the General Prosecutor's Office stated that Tokmadi fell from a pull-up bar and that he has no complaints. Investigators demand me to recount the information about torture, threatening me with criminal prosecution. As a result, in the end of June 2017, I was forced to leave Kazakhstan with my 2 minor children. I fear a lot for my family. I kindly request that you help stop the illegal harassment of my family. Strong and publicly condemn the action of Kazakh authorities. Thank you for your attention.
Thank you. I will now give the floor to our colleagues from the OSCE Counterterrorism Unit, followed by Panel Reform International.
Thank you very much, Madam Chair. Manuel Eising from the Action Against Terrorism Unit of the OSCE Secretariat in Vienna. We have an excellent cooperation on many fronts with ODIHR to ensure that our efforts in Vienna are in line and supportive of OSCE human dimension commitments. And since last year, we have also strengthened our cooperation with the OSCE representative on freedom of the media, RFOM. And starting briefly about RFOM, we just last week here co-organized a very timely side event on countering violent extremism and securing freedom of expression online, possibilities and limits. This side event helped to expose the interaction between the exercise of the human right to freedom of expression online and national security interests of participating states, and the outcome of the side event could maybe set the tone for a high-level event later this year or in 2018. As to our cooperation with ODIHR, historically, our closest collaboration has been in the field of preventing and countering violent extremism and radicalization that lead to terrorism, world, and this topic continues to be prominent on the OSCE agenda, following the adoption of a comprehensive declaration by the OSCE Ministerial Council in Belgrade in 2015, our portfolio in this field has grown rapidly. And many of the policy recommendations outlined in this declaration are also echoed in the UN Secretary General's plan of action to prevent violent extremism. In this regard, let me just briefly touch upon the Leaders Against Intolerance and Violent Extremism initiative live. We are very pleased that ODIHR is contributing to and supporting this flagship project, during which we are striving to empower civil society responses as an effective strategy to prevent and counter world. Furthermore, we are working with ODIHR and other OSCE executive structures in the framework of our communication campaign, OSCE United in Countering Violent Extremism, where we managed to reach up to 37 million people through social media. I will distribute a more comprehensive statement to the organizers. Thank you very much.
Thank you. I will now give the floor to Panel Reform International, followed by the Delegation of Liechtenstein.
Thank you, Madam Moderator. Take into consideration the increasing risk of violent extremism and radicalization that leads to terrorism and detention, and that the issue of managing violent extremist prisoners has become increasingly prominent in recent years, Panel Reform International would therefore like to highlight some considerations taking into account our practical experience on conducting work in Kazakhstan and Kyrgyzstan. PRI has been aware for some time now that prisons can play a critical role in both triggering and reinforcing the radicalization process. Given that many conditions conducive to violent extremism and radicalization in prisons appear to stem from human rights violations, it is essential that OSCE participating states follow a human rights-based approach to prevent terrorist radicalization in prisons. This must encompass efforts to improve overall prison conditions and ensure human, safe and secure conditions for all prisoners, but also human rights-based measures concerning the management of violent extremist offenders and their reintegration and rehabilitation. PRI experience in the area has shown that efforts on preventing radicalization that are based exclusively on security and control are not sufficient. In overcrowded and dilapidated prisons, where prisoners experience discrimination based on their faith or origin, recruiters for extremist groups find it easier to attract followers. PRI would also like to highlight the important role of prison staff. Assessing and addressing risks related to radicalization requires prison staff that are well selected and trained, as well as tools to aid assessment and classification of prisoners. Training involves being able to recognize signs of radicalization, understand the complexities of reintegration and rehabilitation measures, and secure their own safety and the safety of inmates as required by the Nelson Mandela rules. Particular tools may be necessary for specific groups such as women or child prisoners. Finally, we need to understand the root causes causes of radicalization, work on prevention programs, and address alienation. Post-release aftercare programs should be developed to respond to the specific characteristics of this group of prisoners with the aim of reducing the likelihood of recidivism. In conclusion, all governmental entities engaged in preventing violent extremism should cooperate closely together, and international collaboration and exchange of experiences are a necessity given that violent extremist crimes often transcend borders. Thank you.
Thank you. I will now give the floor to the delegation of Liechtenstein, followed by Human Rights Center Memorial. Liechtenstein, you have the floor.
Thank you, Madam Moderator. Terrorists attack innocent citizens and spread fear, thereby deliberately targeting our shared values. When tackling these abominable acts, we should not forget that state action neglecting the protection of human rights can itself contribute to the erosion of the values that we are committed to uphold. Neglecting and eroding the rule of law in the face of grave threats is not an option. This particularly includes the absolute prohibition of torture and other cruel, inhuman and degrading treatment or punishment, a principle that all participating states committed to in several final acts. In our view, the death penalty itself constitutes a cruel and degrading form of punishment that conflicts with the most basic human right to life. Other basic rights might also be infringed by counter-terrorist measures. Broad definitions of terrorism can threaten the rights to freedom of expression and association. Mass surveillance on the internet can undermine the right to privacy. Law enforcement and military operations often walk a fine line between legitimately targeting terrorists on the one hand and unacceptably neglecting the rights of innocent civilians on the other. Governments must abide by the principles of legality, necessity, and proportionality in their actions against terrorism, thereby protecting the human rights of all persons under their jurisdiction. On the basis of the OSCE consolidated framework for the fight against terrorism, we believe that the root causes of violent extremism and radicalization leading to terrorism should be addressed by the participating states, while the respect for the rule of law and human rights is ensured. Thank you.
Thank you. I will now give the floor to the Human Rights Center Memorial, followed by the Center for Support of International Protection. Memorial, you have the floor.
Participants, in the context of this issue, I would like to pick up the question of anti-extremism law in post-Soviet countries. Similar models exist in Russia, Kazakhstan, Kyrgyzstan, and Tajikistan, and the clear shortcoming is the lack of precision in defining extremism, which means that it can be used for purposes which are far from countering extremism. I'd like to address two main issues. The first is the question of lists of extremist and terrorist organizations. 15 years of experience of such a list in the Russian Federation and similar lists in the countries I've mentioned show that a large number of religious organizations are included on this list without justification. The legal model is built in such a way that appealing against inclusion is not possible. It's not possible to review the assumptions leading to inclusion. It's not possible to speak with a voice other than that of the security services. This has a serious effect on human rights. One can be deemed to be belonging to an extreme organization, and this can lead to serious consequences. Whereas in fact one is a member of a non-extremist organization which does not espouse violence. Another problem is the key role of expert reports, psychological, linguistic reports used in determining guilt or not. A large number of these expert reports and we've looked at a number of criminal cases which have involved such reports, do not have a clear scientific basis, and the conclusions are not undebatable. Once again, the legal mechanisms do not foresee the possibility of challenging such results of expert reports. In conclusion, in July this year at the International Conference in Kyrgyzstan on the discussion of these problems, there was an unexpected result from countries. Kyrgyzstan began to prevent the organizers of the conference coming to the country, including myself. So I'd like to take this opportunity to call on the Kyrgyz Republic to review this decision. And thank you very much.
I will now give the floor to the Center for Support of International Protection, followed by the Office of the Ukrainian Parliament Commissioner for Human Rights. Center for Support of International Protection.
Thank you, moderator. Ladies and gentlemen, participants in this meeting on common dimension, I would like to mention to OSCE participating states and other interested parties that there is a need for expert support to make the activities of the state administration more effective when it comes to ensuring minimum acceptable conditions of detention. We have a national center to prevent production, and we have an ombudsman, and they have identified cases of women being kept in isolation, the conditions under which they were transported to court were examined, and it was established that there were a number of violations of the human rights law of Kyrgyzstan. There were comments that were inappropriate made to these women. They were often accompanied when transported by men. There was sexual harassment on those occasions. In the south of Kyrgyzstan, there are 22 cells, and one of them is quite notorious, cell number 53, and it was used to hold women in isolation when in temporary detention awaiting trial. But it would take some 4 to 5 hours to travel from there to the court, and it's very dubious that they should be accompanied on those occasions by male guards. And on the occasion of waiting trial, women are often forced to sit in cages together with men as they await their turn in court. And very often the men in those cages are charged with much more serious crimes than the women. So thank you for your attention, and please do appeal to the authorities of my country to ensure more acceptable conditions of detention, especially for women.
Followed by the Astana City Collegium of Advocates.
Hello, dear members of this meeting. I would like to draw your attention to the situation in Peninsula of Fear, of so-called occupied territory of Crimea. And I would like to inform you that in the 12th of September, it was the next case when the person who is Ukrainian citizen was tortured in the territory of Crimea without any reaction from prosecutor office or from another organs of Russia Federation. And I must say that it was at least the 7th case during this 3.5 years of illegal occupation of when I applied to my Russian colleague ombudsperson of Russia Federation concerning torture and concerning effective investigation without any positive result, I must say. And I must draw your attention to this systemic lack of effective investigation annexation at the territory of Crimea of all facts of tortures. And I strongly support the idea of Ukrainian non-governmental organization that Ukrainian ombudsperson must be effective in all territory of Ukraine, including realization of function of national preventive mechanism against torture first, and second, that the occupied territory of Crimea must be open for international organization, including European Committee Against Torture, including OSCE SMM mission, because it's really very important to stop torture at the territory of occupied territory of Crimea. Thank you.
Thank you. I will now give the floor to the Astana City Collegium of Advocates, followed by the International Platform Global Rights for Peaceful People. Astana City Collegium of Advocates, please.
Thank you very much, participants. I'd like to extend you a warm welcome from our Bar Association. I'd like to share with you some issues in accessing justice for those who have been detained. The first problem is getting the legal assistance. Lawyers are attributed in once the individuals have been charged, and any legal assistance from outside is not under the legal provisions that exist. We do not have a situation where those individuals who've been charged are being given qualified legal help. And we also have the problem that during detention there are cases of torture. Now, in our country, the situation is that there's no guarantee of legal support. The second problem is legal criminal prosecution and the testimony achieved during that time. The third problem is the lack of a legal code applying to violent behavior. The brutal behavior does not come under torture and the legal provisions, and that has an impact on whether or not these acts can be identified and charged. We need to work in accordance with the Istanbul Protocol. We're looking at the availability of psychologists, medical support, and appropriately qualified legal enforcement agents. So we need to work together, ensuring that all stakeholders are involved and ensure that the right for legal assistance is observed, that improperly gained testimony cannot, and that violent treatment is clearly identified as a form of torture in accordance with the Istanbul Protocol, and the application or the use of torture in that way during these times must be identified and eliminated. Finally, we need to train psychologists and medical staff to provide their support in accordance with the Istanbul Protocol. Thank you.
I give the floor to International Platform Global Rights for Peaceful People. Let me just remind the delegations that they can sign up if they want to exercise their right to reply on the list behind me, and also apologize that due to time constraints we will probably not be able to accommodate the reserved speakers list. And now I will give the floor to the International Platform Global Rights for Peaceful People, followed by the Delegation of Belarus.
Moderator, dear experts, I represent the International Platform Global Rights for Peaceful Peoples, of which I'm the president, and I would like to speak to the terrible situation in the penitentiary system of Ukraine. There are many violations that occur there, but maybe I'll concentrate on one. Human Rights Watch, International Human Rights Defense, has accused Ukrainian authorities with torture in Ukrainian prisons, and in particular the organization has said that the security officers of Ukraine, when individuals are arrested, torture them. And it was a 20-year-old Daria Mistikasha who works in Moscow, and she came to Ukraine to see her mother, and she was held at the border when she wanted to leave the country, and she was charged with treason, and she was detained in pretrial detention, and she was subject to torture, and then she disappeared. According to the director of the Human Rights Watch, responsible for Eastern Europe and Central Asia, the level of conditions in Ukraine is absolutely unacceptable. There is absolute impunity in the case of abuse of power and torture, states that director. Last year, people working for Amnesty International have reported that there is torture of detainees, Ukrainian nationalists in the Donbass area, and the current Ukrainian authorities keep the innocents in jail, but those who are real criminals are at the highest levels of power. There was the assassination of May of last year, and the killers are still on the streets, whereas some very innocent people have been kept in prison for 3.5 years. And just a few days ago, a court confirmed their sentences on the basis of just one witness. Sergei Dolzhenkov was accused of separatism because on 24 March 2014, he simply said a few words about his ideals. Now, we would call on the OSCE to send a commission to investigate the situation in Ukrainian prisons, and in particular to investigate the case of Sergei Dolzhinsky. Thank you for your attention.
I will now give the floor to the delegation of Belarus, followed by the interregional human rights group Voronezh. Belarus, you have the floor.
Thank you very much, Madam Moderator. I'm not going to repeat our position on the issue of death penalty, which is well known for the sake of time. I would like to draw the attention of the audience to the active work which is continuing in Belarus, including with the involvement of parliamentarians and civil society aimed at creating public support and conditions that would facilitate the non-application in judicial practice of such a punishment as death penalty and ultimately lead to a moratorium or its abolition. It was for this purpose that in December 2016, the working group on the death penalty as a means of punishment used in the Republic of Belarus resumed its work in the newly elected Belarusian parliament. A number of events dedicated to a comprehensive review of international trends in the application of the death penalty and the public attitudes to the topic are provided for in the National Human Rights Plan. I should like also mention two conferences on the abolition of the death penalty that were organized by the UNDP and also by the Council of Europe in cooperation with the Ministry of Foreign Affairs of Belarus in December 2016. I cannot but mention a constructive cooperation with the United Kingdom on this issue. In particular, on the 3rd of March this year, the Belarusian parliamentarians met with the executive director of the death penalty project and member of the death penalty expert group of the Foreign and Commonwealth Office of the United Kingdom, Parvez Jabbar, and the Secretary General of the non-governmental organization International Commission Against the Death Penalty, Madrid, Assunta Viva Cavalier. In March 2017, a study visit of some working group members was organized to the UK to discuss the death penalty issue. The most recent example is the visit of the group of international experts headed by the Assistant Secretary General for Human Rights, Ivan Shimonovich, and accompanied by the working group members to the Grodno region to discuss the death penalty issue with the representative of civil society, academic community, and local authorities. It took place last week on the 11th of September, and this practice will be continued as well as the practice of study visit with the assistance of the Council of Europe. In conclusion, Madam Moderator, I should say that against the background of awareness-raising activities, the percentage of the Belarusian population supporting death penalty has diminished. However, it still constitutes the majority. And Belarus expects that our partners will take due account of the need of deep comprehension, analysis, and preparation prior to introduction of a moratorium with the ultimate goal of death penalty abolition. We stand ready for the open dialogue and cooperation on the issue of the death penalty. Thank you very much, Madam Moderator.
Thank you. I will now give the floor to the Interregional Human Rights Group Voronezh, followed by Kylym Shamy, Human Rights Protection Center.
First of all, I'd like to note that the Russian Federation in the last 10 years has done a large amount of work to develop the legal basis for social oversight, particularly with regard to detention. The Minister of Interior Affairs and the prison system regularly report on their work to independent oversight authorities. All of the conditions have been created for the adoption of the provisions of the protocol against torture. At the moment, the national mechanisms against torture have faced limitations, facing difficulty in access of representatives of NGOs. The source of the limitation de jure is not the government, but rather the members of the social chamber, which is appointed by the president to some extent, but the members are supposed to act independently. They are regularly changing the selection of the oversight authorities process, and the quotas relating to the makeup are changing, and that has enabled the forum to affect the number of NGOs. Up until recently, over 50 NGOs were involved. Now it's gone down to under 20. So the diversity of ideas is being limited. It's very important in the OSCE to have such diversity of ideas. Obviously, the Russian Federation has the right to control this process, ensure that there is transparency in the process and the adoption of quotas, and ensure that there be more appropriate NGOs involved in the oversight process. Thank you.
I'll give the floor to Kylym Shamy, Human Rights Protection Center, and then ask if the CBC TV channel absent before is already in the room. Kylym Shamy, you have the floor.
Thank you. My name is Ization from Kyrgyzstan. Let me start with my recommendations. The first one is the following. For ODIHR, to constitute a working group of experts who would develop some guiding principles for participating states to assist them in drafting laws on combating and preventing terrorism and extremism in a way that fully respects human rights. Second, that the OSCE call on Kyrgyzstan to respect the rights of detainees charged with terrorism, that they have the defense of a lawyer, that they not be tortured, and that they be given fair trials. Third, call on Kyrgyzstan to respect human rights in the context of combating terrorism when carrying out so-called special operations to destroy terrorists, as they are called. And when using firearms, fully to respect the right of individuals to life, an absolute right. Now, our investigations show that individuals held on suspicion of terrorism are subject to torture. They are not provided with lawyers. They're not provided with medical care. They are not able to communicate with loved ones, relatives, friends, or a lawyer. They are not given access to journalists. We have identified a case where an ombudsman was not admitted to a trial of some individuals charged with terrorism. He could not even attend the trial. And the individuals concerned were sentenced to 20 to 25 years of detention. As for lawyers, when they become involved in a case, they have to provide all of the materials that are in their possession, and they are not provided with the documentation and evidence available to the prosecution. So I hope that these recommendations can be taken into consideration. Thank you.
BBC TV channel is in the room.
CBC channel not in the room, in the corridor, but CBC TV channel is state-funded TV channel from Azerbaijan, and I'm surprised, I'm from civil society from Azerbaijan, and I'm surprised how you put CBC TV channel, which is official funder state-owned company from Azerbaijan, 100% financed by Azerbaijan state. This is state body. It's not civil society institution. Sorry.
The speakers list contains representatives of organizations that are registered as participants of the Human Dimension implementation meeting. Is that it does not specify who these people are. But if the representative of this speaker is not in the room, then the next one that we missed on the list is the regional Bulgarian National Cultural Autonomy of the Republic of Crimea, named after Paisi Hilendarsky.
Madam Moderator, we have point of order again.
I will give the floor to the apologies, извиняюсь. I will give the floor to the delegate of Ukraine who raised the point of order now.
Madam Moderator, the delegation of Ukraine feels sorry that after yesterday's point of concern raised by the delegation of Ukraine, the United States of America and Canada, you are intending again give the floor to this speaker. This speaker is representing Bulgarian minority in the Crimea. And we don't have any problems with it because Ukraine supports all the minorities in our country. But for Ukraine and for Congress of Bulgarians of Ukraine, there is only one organization existing in Crimea, which is Crimean Society of Bulgars, named after Paisi Hilendarsky. This representative, who is here and who is now again wishing to speak on the topic of today's working session, representing the occupation authorities of Crimea. Why? Because he is a member, first of all, of the chamber of the civil organizations of so-called Republic of Crimea, which is controlled by the government. That was just, presented to us the representative from Voronezh NGO from Russia. Again, we would like to reiterate that this organization is registered according to the law of the Russian Federation on the federal cultural autonomies. I would like to call all the participating states. I would like to call upon you to withdraw from this indirect recognition of alteration of the change of the status of Autonomous Republic of Crimea. Because in Ukraine, in any other participating states but Russia, there could be organization with such name, National Cultural Autonomy. That's why the delegation of Ukraine call upon you to take the speaker to be ruled out of order and to leave the room. I thank you.
Thank you very much.
Госпожа модератор.
Уже.
Российская делегация.
The Russian delegation has a point of order. We will then interrupt everybody who will talk about the annexation of Crimea in Ukraine. Thank you.
If I could just respond, let me recall the Helsinki consensus document of 1992 that ODIHR is obliged to follow, that recalls to make open to NGOs all plenary meetings, ODIHR seminars, workshops and meetings, and human rights implementation meetings. End of quote. And then consensus decision number 476 that calls on ODIHR to, quote, that all participants have equal access to the list of speakers in order to provide their contributions to each working session, end of quote. Since ODIHR is bound by these consensus decisions, I will now return the floor to the speaker.
Спасибо большое. Thank you very much indeed, Ivana Bajer. The Regional Bulgarian National Cultural Autonomy. Our organization was founded, and this is information for our colleagues in Ukraine. I'm the president of this organization. I've been president since '91, and then we were called the Crimean Republic Organization of Bulgars. And with regard to the colleagues who have taken the floor today, I've lived in Crimea for a number of years, and I must say there is disinformation about what is going on in Crimea. What we have today is peace and quiet. In Crimea, we have all the necessary conditions to develop as national autonomy, and we have everything that we need in order to ensure that human rights are applied, terrorism is fought. With regard to the legislation of the Russian Federation and organizations such as ISIS, when there are representatives of such groups in Crimea, the law enforcement agencies have to take preventive steps to ensure that they cannot spread terrorism in Crimea. Now, many say that this is a violation of national minorities' rights, and this is some kind of persecution. That's absolutely not the case. Furthermore, in the Russian Crimea, the Russian observer committees are established, monitoring committees, which, in accordance with the law of the Russian Federation, bring together a number of civic organizations which have experience of applying human rights on the territory of the Republic. Anybody wishing to find out more about how that works and what happens, for example, in the prisons of the Republic, can go to these civic monitoring bodies. I'd like to urge all participating states and all those interested to pay attention to, for example, the provision of electrical energy in winter, which was stopped, as was water. Could you submit your full statement? I will. I'm just closing. This is clearly terrorism on behalf of the Ukraine states, the 2.5 million inhabitants of Crimea. Thank you.
Thank you. I have 11 rights of reply on my list. And I have one other organization that did not show up before, and this is the Institute for Reporters' Freedom and Safety. Is the Institute for Reporters' Freedom...
Thank you, Madam Moderator. I will make my speech in Russian.
Ladies and gentlemen, I would like to draw your attention to the fact that torture is unfortunately a political instrument being used by the authorities of Azerbaijan more and more frequently against political opponents. And let me just provide some fresh examples. A blogger detained, Mehman Kalandarov, in February of this year was subject to systematic torture, after which he was found hanging in his cell. To this day, it is not clear whether he hung himself, whether it was a suicide, or whether he was hanged. And we thank many participating states of the OSCE, in particular the United States and the EU, that reacted strongly to this case, but we would call for more severe measures to be taken against the individuals because of whom people are dying in detention cells. My brother is a journalist and a human rights defender. He was arrested on the 3rd of March of this year, and the pretext for his arrest was a charge of defamation. He supposedly had slandered the police by stating that they were guilty of torture. He was detained illegally by people in masks. They subjected him to electrocution, applied other means of torture, and after some significant international reaction, he was released, and only because he had in fact lost consciousness. First aid was, experts were called, and there was fear for his life. A month later, he was arrested again by investigators in Baku, supposedly once again because he slandered the police and charged them with torture, and he was sentenced to 2 years in jail. But in fact, the reason for the arrest of my brother is that he is a source of information for hundreds of thousands of people, real hard information, which is negative about the authorities in Azerbaijan. So we would call on the international community to apply strong sanctions against the authorities and draw attention. Just recently there was a case that was won by the victims of torture before the European Court of Human Rights. I myself have won a case in the European Court of Human Rights, but individuals who were guilty of committing torture against me have never been punished. And despite the fact that I, as a human rights defender in Azerbaijan, am quite well known there, and unfortunately I've had to leave the country. It's a country in which there are hundreds of political prisoners. They are tortured, and that is done with full impunity, which is unacceptable. Thank you.
Rights to reply. Our interpreters will probably leave us at 13:15. So I would kindly ask to make the right to reply statements not longer than 1 minute. And I have France on my list, followed by Uzbekistan.
Thank you very much indeed. First of all, I'd like to recall that France's position with regard to the illegal annexation of Crimea has not changed. Also, I would like to provide some information to participating states on the matter of the recent anti-terrorist bill, which was since the attacks in France on the 13th of November 2015, France has been in a state of emergency in order to counter an imminent threat to public order. And the last extension will come to an end December 2017. It's a temporary state of affairs. With the development of new forms of terrorism, however, the threat is ongoing. So we need permanent ways of countering that threat and preserving state of emergency for exceptional circumstances. Explains the changes in the law. The bill has been submitted to the Conseil d'État, the Council of State, and this has made recommendations that the government will consider. We also have ongoing dialogue with the Council of Europe on this bill, particularly with the Commissioner on Human Rights, who has expressed concerns with regard to specific measures, and the government provided explanations. In the context of the OSCE, we've submitted voluntary reports on the state of emergency, and we will be happy to continue dialogue with the relevant international organizations, including the OSCE, on this bill and on other measures to strengthen the security of our country. Thank you.
I now have Uzbekistan, Spain.
Ladies and gentlemen, I would like to draw attention to some statements to the effect that individuals detained in because they're on a sort of a blacklist. But we're talking about individuals who are charged with very serious crimes, such as murder and others, and obviously we must take into consideration their rights, but also the rights of the victims, not just the perpetrators. Now, it seems to have become popular to charge Uzbekistan and neighboring countries for carrying out special operations that are done illegally with torture and so on, but often this is done on the basis of information that is 5 or 6 years old. So let us be more cooperative in trying to uproot the evil of torture. Thank you.
Armenia.
Sí, como anunciado en mi declaración hace...
Yes, as I said in my initial statement, I would like to respond to Mr. Nouri. The case that was referred to took place on the 5th of February 2016. There was an audience of children. There was a slogan used which was long live Al-Qaeda, long live ETA, the last being a terrorist organization, and there was a judge, police aggression, and a nun with a crucifix. The case was related to glorification of terrorism. As has been said, it was dismissed. In 40 years, we have never been found guilty of violating Article 3 of the European Convention of Human Rights. Thank you.
Armenia, followed by Kyrgyzstan.
Thank you, Madam Moderator. Apologies to the Armenian NGOs, since I need first to exercise my right to reply to the Azerbaijani individual who seems to be indeed interested in the topic he raised. I would like to state that I respect the feelings of the son of the father who is imprisoned in Nagorno-Karabakh. Indeed, in any circumstances, the should stand for his father, and likewise father should stand for his son. And in this way, I hope that he will respect the feelings of Mr. Mekhatsakhanyan, whose son, who was, by the way, younger than you, was killed by your father in the course of his so-called tour Artsakh to visit graves. As for the conditions of your father, I would like to assure you that not only me, but also President of ICRC himself has noted that his conditions of imprisonment are proper, and representatives of ICRC have full and unrestrained access to him and ensure communication of your father with your family. Thank you very much.
Thank you. I will now give the floor to Kyrgyzstan, followed by Azerbaijan.
Спасибо, госпожа.
Thank you, moderator. Ladies and gentlemen, in connection with what was said by Madame Skharova, the delegation would like to say the following. Mr. Skharov was found guilty and sentenced by a district court on 15 September of 2010 for very serious crimes, inciting conflict and hatred within the society. And Mr. Askarov has taken advantage of his opportunity to appeal his sentence, and the appeal court has reviewed the case and came to the conclusion that the decisions taken in the first and second courts of first and second instance were justified. In April of 2016, the UN Committee on Human Rights looked at the Askarov case and determined that there was a violation of the Fundamental Covenant of Civil and Political Rights. But it was not confirmed that he had been charged because of his human rights defense activities, and they also did not find that the presumption of innocence or the right to a fair trial had been violated. In July of 2016, the Supreme Court of the country has reviewed the case on the basis of new circumstances that came to light. Now, the new review of the case was absolutely open. There was an open trial. Representatives of human rights defense organizations were present, together with journalists and representatives of international organizations. It was, in fact, made available online. And in the course of this, thanks to witnesses' testimony, that the sentence was fully justified. And so a new verdict was handed down. He was found guilty of killing a police officer and of inciting to conflict and hatred within the society. So the original verdict was confirmed. Thank you for your attention. More detailed information about the Askarov case will be made available on the site. Thank you.
Madam Moderator, in follow-up to the intervention by the Armenian delegation, and I would like to state that Armenia periodically makes different provocations on the occupied territories of to make the negotiation process eternal. One of these provocations took place in April 2016. Azerbaijani civilians were shelled from the Armenian artillery. Nearly 10 civilians, including children, were killed. Armenia's offensive actions also caused casualties and injuries among the servicemen of the armed forces of Azerbaijan. The ICRC facilitated the handover between the sides of the bodies of those killed in action following the escalation. Subsequently performed forensic medical examination registered numerous signs of post-mortem mutilation of the bodies of Azerbaijani servicemen by the Armenian armed forces. Photos and videos of Azerbaijani servicemen subjected to post-mortem mutilation and other inhuman and degrading behavior by Armenian occupying forces were published in the Armenian mass media. Armenia's direct and deliberate attacks against the Azerbaijani civilian population and civilian objects, as well as inhuman acts against Azerbaijani militaries, constitute a serious violation of international humanitarian and human rights law. The Azerbaijani side once again against the Armenian side of its obligations under international humanitarian law to respect the rights of civilians during the armed conflicts. Finally, we reiterate once again that taking hostages, as well as torture, cruel, inhuman, and other degrading behavior against the civilian population of the territories under occupation is prohibited under international humanitarian law. We also call on Armenia to release the captured Dilga Maskarov and Shahbaz Guliyev, who currently are subject to torture and degrading behavior. Thank you.
I will now give the floor to Canada, followed by the Russian Federation.
Thank you, Madam Moderator. I would like to take this opportunity to respond to Mr. Horry's critical observations in his introductory remarks. The Government of Canada, in recognizing dissatisfaction among Canadians with previously passed national security legislation, has committed to amending problematic elements of the Anti-Terrorism Act of 2015. This issue is receiving the highest level of attention, with the Prime Minister including the task of these legislative amendments in the mandate letter of the Minister of Public Safety. In its recent unprecedented public consultation on national security, Canadians were clear that they expect their rights and freedoms to be protected at the same time as their security. The government's proposed measures would strengthen accountability and provide it with the necessary means to address current and emerging national security threats, while ensuring these proposals are fully compliant with the Canadian Charter of Rights and Freedoms and respect Canadian values. Receiving royal assent on June 22nd this year, the Act to establish the National Security and Intelligence Committee of Parliamentarians will allow parliamentarians to scrutinize the full range of national security and intelligence activities across the Government of Canada. Tabled by the Government in Parliament just 2 days before and currently before Parliament, Bill C-59 proposes a number of measures to enhance Canada's national security framework with a view to keeping Canadians safe and also respecting and upholding Charter-protected rights and freedoms. A couple of extracts very quickly. Part 1 would establish a new National Security and Intelligence Review Agency that would review and report on the lawfulness of all national security and intelligence activities across government and would also investigate complaints. Part 7 proposes changes to the criminal code that would clarify and limit the of certain terrorism offences, as well as ensure that preventive anti-terrorism measures keep Canadians safe and respect their rights and freedoms. We invite those interested in learning more about this process to consult the extensive documentation and past and proposed measures on the Government of Canada's website. Lastly, I will repeat Canada's concerns mentioned at the end of Session 10 yesterday and reiterate our full support for Ukrainian sovereignty over Crimea and the city of Sevastopol. There is no Russian Crimea. Thank you.
Thank you. I will now give the floor to the Russian Federation, and this is the last intervention that will be interpreted, after which we will thank the interpreters, and then have the United States of America, Russian Federation.
Спасибо. Thank you very much indeed, Moderator. With regard to the statements made by representatives of various delegations, I'd like to take the right to reply and once again emphasize that we have repeatedly explained the crimes in the Chechen Republic against LGBT representatives. There has been explanations also given with regard to Jehovah's Witnesses. The Russian law applies in this area and the decisions of the Supreme Court of Russia. Crimea acceded to Russia in accordance with the referendum taken place in accordance with international law as per the UN Charter and the Charter on Human Rights. The points raised by Ukraine and the issues relating to detention and torture are without base. The complaints have not been submitted in accordance with international law. Thank you.
And thank you to our fantastic interpreters for their very diligent service. And I will now give the floor to the United States of America, followed by Hungary.
All U.S. military detention operations, including at Guantanamo Bay, comply with Common Article 3 of the Geneva Conventions. U.S. law requires that the ICRC be provided with notification of and prompt access to any individual detained. Torture and cruel and inhuman and degrading treatment or punishment are categorically prohibited under U.S. law everywhere and at all times. All Guantanamo Bay detainees have the ability to challenge the lawfulness of their detention in federal court. Except in rare instances, all of the evidence relied upon by the government in habeas proceedings to justify detention is disclosed to the detainees' counsel. The United States government has the burden in these cases to assist legal authority to hold the detainees. Crimea remains part of Ukraine. And finally, this dialogue with civil society is undermined when governments use civil society seats to speak on their own behalf. Thank you, Madam Moderator.
Thank you. I will now give the floor to Hungary, followed by the United Kingdom. Hungary, you have the floor.
Thank you very much, Madam Moderator. In my right to reply, I would like to briefly react to some remarks made by our second introducer with regard to the state of emergency regulation in Hungary. State of emergency can be ordered in accordance with the fundamental law of our country. This special legal order can be declared by the Parliament. One of the reasons this order can be announced is an act of terror or a clear and present danger of a terror act. During the time of state emergency, special safeguards and guarantees are applicable, for example, the fundamental law itself, the work of the Constitutional Court, and the exercise of the basic fundamental rights cannot be suspended. This legislative framework, in our view, is in line with international standards and meets the commitment of my country. Thank you very much.
Thank you. I will now ask the United Kingdom to take the floor, followed by Estonia on behalf of the European Union. The UK, please.
Thank you, Madam Moderator. Firstly, I would like to thank both introducers for their excellent presentations, which touched on many issues affecting the OSCE region. The UK remains committed to the full implementation of all our OSCE human dimension commitments, as well as our international human rights obligations. Respect for human rights and the rule of law are essential for a safe, secure and prosperous society. Governments have a responsibility to protect the public. The UK government is committed to challenge all those, be they on the extreme right wing or Islamists, who draw upon and promote ideology that seek to normalize behaviors that run contrary to the shared values that underpin our multicultural, multi-faith society. This is consistent with our commitment to human rights and the rule of law. The UK government's Prevent programme is fundamentally about safeguarding society and supporting vulnerable individuals to stop them becoming terrorists or supporting terrorism. Finally, I would like to reiterate that the United Kingdom strongly condemns the illegal annexation of the Autonomous Republic of Crimea and the city of Sevastopol by the Russian Federation. We do not and will not recognise it. Thank you.
Thank you. And now Estonia on behalf of the European Union, followed by Ukraine.
Thank you very much. I wish to refer to previously heard utterance about the Russian Crimea and about the accession by Crimea to Russian based on a referendum. The European Union, in this regard, reiterates our strong condemnation of the illegal annexation of Crimea and Sevastopol to the Russian Federation, and we will not recognize it. Thank you.
Thank you. And last on my list is the delegation of Ukraine.
Thank you, Madam Chair. I would like to thank the delegation that reiterated the United Nations General Assembly position on the territorial integrity of Ukraine, including Crimea, and would make 2 points in reply. On the situation with indigenous people and national minorities in Crimea, I would really advise the Russian government to go along the order of the International Justice of the United Nations, who mandated to reinstate the Crimean Majlis and ensure the availability of Ukrainian language education in Crimea. That indeed shows the situation with the national minorities and indigenous people in Crimea, and Russian government has made no steps to follow the mandatory order of the ICJ. And the second part on the remarks of alleged disinformation on the situation in Crimea, there are 2 international monitoring missions with a mandate to monitor human rights situation in all of Ukraine, United Nations mission and OSCE special monitoring missions. They report on the situation in Crimea without access, the physical access there. It's very simple. If you want a reliable information, let these 2 international missions in Crimea. You will get all the information you want. Thank you.
Thank you very much. I unfortunately do not have time to give the floor back to our introducers, so perhaps I would encourage you to reach out to them during the break. And before closing this session, I would like to give the floor to Ambassador Strohal on behalf of the chairmanship for an announcement.
Well, thank you, and thank you very much to the 2 introducers. I will be very brief. I just want to draw everybody's attention to an upcoming event which will deal with a related subject, and that is the Human Dimension Seminar on Children at Risk, which will look in particular at the situation of children in detention. It will also look at trafficking in children and at strategies for preventing such situations. And it's here in Warsaw on the 11th and 12th of October in the Sofitel, and also be in conjunction with a regional consultation on the UN Global Study on Children Deprived of Liberty. So we encourage you all to join us at the seminar. Registration is open. We'll close on the 4th of October. Further information by Odia. Thank you very much.
Thank you very much. And I would also like to remind everybody that for the next session, the speakers list opened 1 hour prior to the session, and all participants are advised to arrive early to sign up to the speakers list before it reaches the limit of 50 when it will be closed. And remind everybody again of ODIHR's reception tonight, for which the buses will be provided from the venue at 19:45. Thank you very much, and I consider the session closed.